Your Lordship's indulgence to mention a matter not on the board. Yesterday, the admitted judge of this honorable court has passed a judicial order referring the matter to your
Who?
the admiralty judge
Okay.
has passed an order referring
You will pass on the memo.
seek a matter listing tomorrow, my lords, because
That matter.
yes, that matter.
I was.
Your Lordship was hearing it. Now there is an application filed by the plaintiff seeking modification of that order. Now
I cannot deal with.
no, this is on the administrative side.
So why I find a very unique way of mentioning the administrative issues in the courts.
Here the difficulty is
Because the approach can be made to a registry who is dealing with this, and it can be placed before me in the administrative side to assign a bench. So there is no difficulty of mentioning in the open court.
but the difficulty is this, my lords. The judge,
No, you could have written it. We have seen place it before the registrar to place the file before me in the administrative side. I'll see to it.
Pardon, my lord. Last other than my lord, on 28, I mentioned to the lord, it was filed in connection with nature of PI in the lords. I know this, but now they are given in the
Adjourned to 30th May.
Oh, adjourned to 13th May, sir. There is already. Then why you are mentioning, sir? It will appear on 13th May. Don't worry. Sir, we'll see to it. Sir, we'll see to it. You can't mention in the midst of the matter when it is directed to be listed on a day.
They are continuing the demolition.
So whatever we'll take care of that. You would have invited the attention on that day for an interim order.
Pardon to mention, my lord. The petitioner applied for a license of a.
Please pass on all the memos. Please pass on all the memos. We'll see to it. Don't worry.
Pardon to make mention, my lord. Item number 33.
Yes.
May please be taken up today only because this matter may not be.
We will try our best to reach those matters.
Only 1 second I will refer to mention before your office. This matter relates to non-availability of clean and safe drinking water. Under article.
We'll take care of that, sir. We'll try to reach. Don't worry.
Item 41, the lordship on the last occasion issued by notified special messenger. It's to me. That's made request that law university matter.
Don't remember anything.
This by special messenger.
It is already there. Let us see. Just remind us.
I just
Remind us just when it matter reaches. Yes, call.
Submission item number 1.
Lordship, I am pardon to mention, I am in virtual lordship. It is a elephant corridor matter lordship. It was in the lordship's court. It is delisted. Lordship
Sir, the matter was not taken up. We have directed this listed on a particular day. 2-3 matters which are left over will be listed. Don't worry, it will be listed.
Lordship, I have sent the memo through the registry mail. Lordship, may kindly be taken up next week. That's my prayer.
We'll see to it. Just see to it. Yes, call it.
Item 1.
My lord, in this writ appeal, I challenge the judgment of the Honorable Single Judge, my lord. That is at Annexure 1. In which the petitioner had prayed for regularization of his service under regular establishment before the Lord Single Judge, my lord. The brief facts is, my lord, in January 1997, petitioner was engaged process server.
Yes.
Process server, my lord. Since then, he was continuing in service.
As a process server in what? In a temporary, daily rated or
ad hoc
what?
basis, my lord. Ad hoc basis.
Ad hoc basis.
Yes, since January 1997.
1997, yes.
When he was, and my lord, during his service period, my lord, the authority has requested the department, my lord, for regularization of his service, my lord.
Correct, sir.
That is at Annexure.
Anyhow, then
I'm showing that letter, my lord.
Then what?
Then, my lord, they didn't pass any order. When the matter stood thus, my lord, the finance department had a office memorandum that is at Annexure, that is at page. that is at page 65, my lord, annex of 6 to petition, issued an office memorandum in the subject of commission of annual establishment review report, my lord.
Yes.
In that memorandum, the finance department instructed all the departments, also heads of the department, they had to submit the establishment report in schedule 1, schedule 2, schedule 3.
Yes, sir.
Then, my lord, in para page 66,
Yes, sir.
para 4A, my lord,
Yes.
that is termination of redundant post,
Yes.
in which it has been, my lord, may I place, my lord, 66? Page
Yes.
66.
Yes.
Wherein the termination of redundant posts, all government officers having certain redundant posts which have lost their relevance in the challenging context of time. For example, the post of Treasury Sarkar has become redundant in the context of electronic payment being made through treasuries, and post of typist in issue section has become redundant in the context of full-scale computerization of the state government offices. Post of public works department like workser, grand mulia, carpenter, mason, and road roller driver have lost their relevance as departmental execution of works has been replaced by the contractor-led execution of public work. Such redundant posts are to be identified and indicated for termination in Schedule 1A, Schedule 2A, and Schedule 3A of AER. In case there are men in position against redundant posts, the administrative department will propose such posts for termination immediately after retirement of the personnel holding such in Schedule 2A.
True.
AER in HRMH in the respective.
This is really an abolition of the post. Whoever is appointed, if he attend the superannuation, thereafter it will automatically gets terminated.
My lord, in this post, my lord, the posts are clearly categorized.
Now the question is that you were on an ad hoc basis.
My lord,
Whether your appointment was upon following the due process of the selection.
my lord, that is page 64, my lord.
Yes, to tell us that you have undergone the due process of selection, whatever
My
is
lord,
required was done.
My lord, on page 61, my lord, I'm
Yes.
placing that letter wherein it has been stated that the petitioner having required qualification as.
That is a different thing, sir.
Yes, ma'am.
Many persons possesses the eligibility criteria. That does not mean that they have to be appointed immediately without following the procedure
My lord,
of recruitment.
prior to that, you was NMR basis, NMR, my lord. Then
What basis?
NMR, nominal poster role, ma'am.
Watch.
Then, my lord, ad hoc basis, since 19, being a retrenched candidate, you
Now
was
the difficulty you know where better the constitution-based decision is staring at your face.
My lord, I'm coming to that post, ma'am.
Yes, sir.
That, ma'am. In that notification, office memorandum, my lord, the posts are specified, my lord. Which posts are required to be rotated to be
The
redundant?
question is whether the 10 years you completed from the day when the judgment of the Constitution bench in Umadevi 3 came to be passed. If
Well,
your appointment was 1997, then it was in 2005, and then the 10 years period
2006, my lord. 2000.
that is reported in 2006, but the
Well,
judgment I believe was passed in 2005.
To that effect, the present decision of the Honorable Apex Court, my lord, Jago versus Union of India.
Justice Vikram Nath's judgment you are saying,
My
but
lord.
it says something differently. You kindly read that judgment in a proper manner. What his lordship says.
My lord, I was continuing on the date of filing of my writ petition, my lord, 23 years of service, my lord. All on a sudden, my lord, in that case, my lord, they stated that you report the which posts are required to be abolished, my lord.
The difficulty is that if you have undergone a regular process of the selection, and there was a slightest of infractions or there is a slightest of the violence, I say the violative of certain portion of the recruitment,
Well, in the,
then you can be considered for regularization, no doubt about it.
My lord, in the counter,
But-
my lord, before the lower court,
Yes.
single judge, my lord, they have not stated, but that point was not taken by the government, my lord. Whether you were
So you are the onus initially lies on you to prove that your appointment and on an ad hoc basis was upon following the due process of law.
My lord,
That's your first
my lord,
responsibility.
since there was the appointing authority.
Whether this was against a sanction post,
Yes, against a sanction.
I do not know.
Against,
Have you
yes,
pleaded?
I'm showing my lord. I'm showing my lord.
And then what was the recruitment process for filling up that sanction post?
There was no rule, my lord, general rule, my lord.
There must be some kind of a written examination. There must be some kind of a interview that is to be taken.
Is a group
Then
D post.
Vishweswara Rao's judgment.
Is a group D post, my lord. And the only.
Vishweswara Rao's judgment of the Supreme Court,
Yes, my lord. But
1997 or 1998.
but facts.
That signatures also mentioned about that. Yogi.
Friends, my lord, it is admitted fact that I was appointed against a vacant post. Against a vacant post, that is admitted. When I was continuing, my lord, based on that, my lord.
Uma Devi has created three criteria, sir. That problem. First thing is, it must be a sanctioned post. It must be a vacant post. And the filling up on an ad hoc, casual or a temporary basis must be done upon following the procedures of law. And if you have rendered more than 10 years without any interjection of the court or audit's order continued, then you have a right to be considered for regularization. Otherwise, sir,
I was appointed, my lord.
Tell us that we can go beyond Uma Devi Constitution Bench mandate.
My lord, in a recent decision, my lord.
Please read that, because the recent decision did not nullify paragraph 53 and 54 of the Uma Devi. Never said.
But in the recent decision, in that case, my lord, the persons those you are appointed.
For a long time.
No, long time, even after the judgment of the Uma Devi, my lord.
Correct.
Their cases are already been.
You have been terminated, sir.
No, they are directed to be regularized, my lord.
You have been terminated, sir.
No, my lord. That is the case, my lord.
You are still continuing.
I was still, because I am saying something.
Are you still continuing?
Yes, what happened?
Are you still continuing, sir? Very specific question.
I was never disengaged. Because after this, my lord.
Then why you are challenging the termination?
I am never challenged by that is the wrong in this case, my lord. I have never challenged the termination order. My lord, to that effect, I may permitted, my lord. In this
have they said that your services have been terminated or you are disengaged or discontinued or?
My lord, to that effect, I submit, my lord. I had filed a IA before the single judge for payment of the salary, my lord. In that case, Lord, a single judge directed, if continuing, to pay the salary. In order to dilute that order, my lord, they created a document. I filed a contempt petition. In that contempt petition, a different show was affidavit stating that the petitioner has been disengaged. And in the disengagement order, which is also annexed in my counter, my lord, that is at page your lordship may kindly see. Page 108. My name is not there, my lord. I am not a peon by that, my lord. The honorable single judge, my lord, in the contempt proceeding, in elaborate discussion, my lord, hold that the authority has filed a false affidavit.
Huh?
False affidavit. And
what are you saying?
Yes, that order I have annexed, my lord.
The learned single judge has held that the authorities have filed a false affidavit.
Yes, my lord. Then, my lord, that was correct in an appeal. Contempt appeal, my lord, before the division bench. The honorable division bench hold that.
Why contempt came?
My lord, the honorable division bench to hold that contempt dismissed, my lord. Then matter returned to the single bench, my lord. Against that order, my lord, they went to Supreme Court. They went to Supreme Court.
Now, during pendency of
The
writ petition, contempt was filed.
For what?
For
They
filing false affidavit on counter.
Oh, that is against the interim order.
No.
IA, order passed in IA.
That is in IA means what is this IA?
Yes.
Interim application.
Yes, ma'am.
So any order passed in IA is an interim order.
Yes, ma'am.
So
At that contempt, my lord.
So they say that you pay the entire salary.
Salary, my lord. Because
they did not pay.
Did not pay, I filed.
Then you filed a contempt.
In contempt,
in the contempt, what the single bench did?
Single bench, my lord, hold that the action of the authority is contemptuous.
is contemptuous.
Then
Then
they filed a contempt appeal.
appeal.
Appeal was dismissed.
Correct.
Against dismissal order of the.
They went to the Supreme Court in SLP. Yes.
SLP.
Then
Supreme Court directed you implement the order of the honorable single judge within a period of 6
so
months.
the payment was done.
Payment done up to May 2024. May.
Correct.
After this, my lord, judgment, my lord, they are not allowing me to continue, nor I am getting my salary. Up to May 15th May 2026, they paid me.
26, 24.
24th, sorry. 24th, they paid me salary. As I was continuing in the.
That's what the direction, ma'am.
And
The
this
direction-
same.
Whatever. That means that he was allowed to continue till May 2024. So you have paid a salary. Now, during the pendency of the writ petitions, now then the judgment, recent judgment of the Supreme Court has to be
Yes.
understood.
Yes.
Uh,
Our stand before the honorable single judge, so also before your lordships, is that he didn't face a process of selection. He was appointed against a post. Thanks, Anand.
where is the judgment of Justice Vikramnath? That's the last recognized judgment on this point.
Well, two judgments.
I'm aware of only this.
And another is Sirpalma,
Subsequent or earlier?
subsequently, following that.
That is January 2025.
Yes.
Jaggu, referred there before the single bench?
No, ma'am. That was not.
Yes, Mr. Counsel. Now, after this judgment, have you read it?
Yes, para 15 hours.
No, no. Very extensive judgment in that regard.
10,
So what
13,
you say?
14, para 10, 13, 14.
Now, what to say that it comes to his aid? Similar situation.
To be fair, my submission, my lord, it was his appointment was against a sanctioned force. Only lacuna is he didn't face a process of selection. Continued for long spell, no dispute. Actually, there is no dispute. And this judgment certainly comes to his aid.
So the Honorable Single Judge judgment came in September. And
this was-
Jaggo and other two thereafter.
Thereafter.
That is this
Anyhow.
December and
That is why
January.
those things were not.
And the Sripal case followed Jaggo.
Yes.
And it also says that there was a,
Even
we
for
were the
outsourcing.
part-time in that
Yeah.
Jaggo.
Outsourcing.
They were a part-time and subsequently they decided to outsource those.
Like,
Here, the same thing.
Yeah.
So in that event, it says that when the services which he is rendering is indispensable, the government also thinks that those services are required and decided to outsource it, then why not you regularize their appointment?
that about my land friend didn't place one document into which is going in his aid, page 62.
And even an educational qualifications was, anyhow, so
Para 4B.
we'll dispose of.
That is sanction post. You said that sanction post.
Sanction.
Against sanction post, he has been working as add-on.
You'll automatically get that answer at page 62. 62 of the book. You'll automatically get page 62.
Page
62.
62.
Third, there is a table, man. The third one. Whether the engagement has been against the sanctioned post, answer is yes. This has been given by Regional Transfer Officer Chandigarh to the Under Secretary at the Orissa. This is a government document.
Regular scale of theirs.
Oh. Look at the government advocate is also not disputing that. And he is very fair that he came, that I can't say anything which is beyond the record.
Yes.
And he is pointing out that there is no difficulty. Have you make out a case of any discrimination?
No.
As in Jaggo, I'm asking.
Disputes.
Yes, I have stated in my writ petition, my lord.
Then who has been regularized and why not you?
Yes.
Where?
Why outsourcing basis now?
Oh,
Any illustration?
Regulation.
Any illustration?
discrimination, discriminatory act that somebody offers. Similarly, the placed person, they have been regularized and you are spared. I'm just wanting that.
Yes, my lord.
That was in case of a Jaggo,
My lord, we have been treated.
only on the ground that you do not have a requisite qualification.
Anywhere of this nature of process server?
I didn't.
Odisha कोठी ना?
No, Odisha, in this case,
नहीं कोठी ही ना थी.
that I'll have to take just an Odisha.
No. I'm not close. इतने दोनों चेक करो. By virtue of office memorandum, that it is not. Is it?
Yes, you have not made out a case that was also appointed in this way and his services has been recommended to be regularized. That you have not made out a case. Not a single instances you have given.
Yes, my lord, I have annexed in my writ petition.
What next?
Regarding vacancy, my lord.
This is something,
Mr.
I am asking a discriminatory act.
My lord.
I am talking in the sense of Article 14 and 16.
Yes, my lord.
Ravi
Please tell
Verma. My lord is hinting at Ravi Verma. in income tax department, many persons were regularized, leaving aside certain others.
Yes, ma'am.
So there lies the discrimination. Article 14 Act. In that sense, have you made out any pleading?
I have written my.
That this gentleman who was also appointed with me, he's been regularized, I am not. I just wanted,
My lord, in my office, my lord.
you have
There
not.
is a single post. In that post, I was.
So no discrimination.
I had single post, my lord.
Oh, hot. I have accepted it. I asked this question very simple, sir.
Only one post, single post. I have not.
So, take it.
Any single bench also.
No. Yes.
Definitely. Because please brief देंगे. अब उसको brief मतलब देना है तुझे. Soft copy.
The same judgment. Both are the same judgment by authored.
Became something yes or no.
Maybe sir.
Maybe sir.
Item number 2.
Mr. Dimit sir, may I suggest one?
Madam, I will see, my lord.
Just a minute. In cases of this nature, against the learned single judge order or judgment have been challenged by departments or government. So why don't you take up and ask them to comply or whatever?
Yes.
It's only a
Typical type
suggestion.
of cases.
So that
Yes,
many cases can be,
Yes.
many writ appeals in that line.
You are not correct. We will try our level so that.
I know 3 to 4 judgments I have delivered in single bench. And many other honorable judges also.
Is what
That
the
is-
last occasion I was just referring about the litigation policy.
Policy.
Yes. Yes, your lordship referred that. Actually, I took note of that.
No, Odisha State Litigation Policy of 2011, you go through that I was referring to always when I was, that is Gazette notified. Odisha State Litigation Policy, that is in the lines of National Litigation Policy. No, National Litigation Policy, they have adopted and they have specified certain set of Odisha State Litigation Policy. That is Gazette notified.
So nice thing, that is what ought to have been, unnecessarily not burdening the court.
Yes, my lord. I understand.
Repeating the same
Yes, same
principles
thing.
on and again.
Now, on a question of law, decision has been made after
Already,
this on
yes.
report. Thereafter,
Thereafter.
keeping those cases pending of no
Correct.
end. Yeah, I understood that. After your lordship said that, I took note of it and we are trying to.
Now, when my brother
Yes.
referred it, please go through it and
Yes.
pass on the copy also.
Yes.
to me.
Yes,
That what is that policy?
Google to मतलब various.
The state of West Bengal has not adopted. State of West Bengal has not adopted. Is what
National Litigation Policy is 2010. That is, again, it is adopted and some additions are there in State Litigation Policy in 2011.
no, many state has already adopted, except few. That's why I was referring. Yes. Yes, call this.
Item 2.
Yes, sir.
Item number 2.
My lord, I will see, my lord.
Yes, sir.
My lord, on 9th of April 2025, your lordship has directed the government to file the report, and the government has taken time to file the report along with the affidavit by today. But till today, they have not filed a report nor served a copy to me, so that I will file the reply in this case, my lord.
Affidavit was directed to be filed. It has been filed already.
Already filed.
Yes, my lord.
Then he says the copy is not served, not filed.
No, it has not come on board. When have you
It has not come on board.
I am giving the date, my lord. That
must
was
be
filed on-
yesterday or day before yesterday.
Yes. It was. 28th it was filed.
28th,
That is
it has already been filed.
He is absent because.
How can they get an access to the copy?
No, we find. That's a subcenter.
Correct.
They will
How can
serve,
they get-
they will serve.
You please serve, why you do not serve it?
The government will file the affidavit to before your lordship and
Mr. Singh,
me.
It has already been filed, sir. It has already been filed, but it is not shown in the system. The
But not
government advocate is saying that he has filed on 28th April. So copy has not been given to you, sir. We appreciate it. We understand.
Yes,
So
madam.
we are passing a direction upon him to immediately serve a copy upon you.
Yes, madam.
Yes.
Mr. Singh, you have any associate here?
Madam, not
Represent, you are from Khurda.
no, madam. I am not a book, sir. I will reach.
You are appearing through High Court Khurda.
I could be at Bhubaneswar. And from Bhubaneswar, I am.
So it is difficult on their part to serve the copy today. If you have any associate, they can collect.
I will collect it by launch, madam. I will reach and I will collect, madam.
That is the regular practice of.
Yes, I know.
Madam.
I'll give
Today
it.
he is in Bhubaneswar, so it is,
That is
you may
that-
not
that
be
was-
able to serve
was-
right
yeah.
now. If he had any associate
Yes,
here,
yes, he could
he
have
would have
collected.
served.
And I will collect. I will collect after lunch.
The counsel for the petitioner submits that despite the direction passed upon the state to file a counter affidavit, no counter affidavit has yet been filed. Next paragraph. The aforesaid submission of the petitioner is refuted by the additional government advocate appearing for the state. To stop. According to him, the copy of the counter affidavit has already been filed in electron on 28th April 2025.
Yes, ma'am.
To stop. We do not find the reflection of the factum of filing the counter affidavit nor we find that the copy thereof has been served upon the petitioner. Stop. Mr. Das, the additional government advocate, fairly submits that the copy could not be served. Copy of the counter affidavit could not be served upon the advocate appearing for the petitioner, and he undertakes to serve the copy through electronic mode or what? By physical what?
Physically, I will collect, madam, today.
When you will collect, sir?
Today, madam, after lunch. From the agents.
In course of this day. To stop. The counsel for the petitioner prays for a leave to file rejoinder to the same. Let the rejoinder be filed within a week from this. This is the matter after that.
On 12th.
Yes, 12, sir.
Oh, okay.
Item number 3.
Today I have filed for the registry man.
On behalf of
On behalf of Mr. Das, Ms. Das, I have filed my appearance in the registry also today
You are appearing for whom?
for the petition, appellant man,
So why you filed your appearance today?
because it is not transferred to me today.
Oh.
Because the council was
Appointed
appointed as additional standing counsel.
Yes, possibly CS.
for that reason, it's handed over the file today.
What do you want?
Next Monday, if your lordship will speak, then I can address your lordship on the merit of the case. Because it is a cancellation of the
Yes,
HT
yes.
certificate.
Prayer next Monday. Yes.
Item 4.
Government, next week, madam, on behalf of Mr. Da. Next week,
Why, sir?
it's not there, madam. That's really approved this case, it's not there.
Actually, he telephoned me. He requested
Yes. Next week.
On 8th. Item number 5.
May I please, your lordship? Lordship, it is a matter relating to disbursement of death benefit and funeral expenses. For death
Funeral
of
expenses and a death benefits.
minor. For a death of the husband of the appellant. That has been.
He died in harness.
Yeah.
He died in harness or what? When during service?
My lord, there is a scheme, Odisha Nirman Shramik Kalyan Yojana, under which the petitioner claimed such benefit. That has been rejected by the.
What is that benefit? What is the, explain what is the sum and substance of that scheme?
My lord, the Odisha Nirman Shramik Kalyan Yojana, there is a scheme of the state government, my lord,
Correct.
under which a board of the construction worker board there is, who registered the labors under which the scheme is. Under this scheme, there are so many benefits like
The construction laborers,
minor,
they are benefited by that scheme.
minor.
Whether privately engaged or government. No, it's a privately, everybody.
minor.
Yes, then
Any labor who has been registered under the
True.
board, he can.
that is mandatory registration. And
Fine.
then
Then the husband of the appellant has registered himself as a registered labor under the welfare board.
no, what is the beneficial scheme? What that scheme says that what
Scheme says that different benefits like death benefit of the beneficiary, death in
natural death as well.
any kind of a death, even if it's accidental or natural.
Right.
Normal death, in case of a normal death, the beneficiary can get the benefit.
Correct.
Other benefits are also there, like daughter's marriage.
Okay.
There are so many benefits.
Anyhow,
The husband of the petitioner, appellant,
was a laborer. He registered himself with the agencies, whatever, the
Mine.
board,
Mine.
and then he died.
During
He
the
received a natural death.
Mine.
Yes. Then he died. Then you applied for
Death benefit and funeral expense.
what death benefit means?
Death benefits mean any kinds of a death, the benefit is given, man.
Consolidated amount is given or
Amount of 2 lakhs for a death benefit and 5,000 for funeral expenses.
funeral. So she's a 2,05,000 rupees.
Mine.
So you applied.
I have applied.
Why they rejected?
My lord, for the inaction of the opposite party, state board council, my lord, I have filed a writ petition.
No. Why they rejected?
And ground of it, honorable single judge has rejected on the ground that.
Why on what ground
It is not rejected, man.
they kept it pending?
It was pending. During the pendence of my application, I have filed a writ petition before honorable single judge.
Correct. Then
Single judge has rejected my claim.
why?
For non-payment of a contribution amount of 50 rupees.
That was the mandatory that you have to continue
My lord,
paying your contribution.
my lord, the statute has said that in case of a non-payment of the contribution amount, the beneficiary shall be seized from the membership.
Okay. Then
But my membership has not been seized.
oh,
During the
so
continuance of my membership, no proceeding was initiated for my cessation. No notice was issued to me for my cessation. No such.
what that
cessation
scheme
certificate.
says that if the contribution is not paid for a certain period,
3 years.
then 3 years, then automatic cessation
No.
or what?
No,
What it says?
Statute has not specified like that.
Can you show me that particular portion of the scheme?
My lord. My lord, that has been already reflected in the impound order. My lord.
Into this is
16,
72
page, just on page 39 of the writ petition.
what?
That
39 of the
39 of the decision.
okay. No, what is this?
This is notification.
Oh,
No,
this is something else.
That's counter. They have filed D/2 annexer.
Oh.
That's 38. That is gazette notification. That is notification by Labor and ESA Department. That is called the Odisha Building and Other Construction Workers Regulation and Regulation of
No,
Employment.
this regulation condition of service amendment rules.
Just
A certificate of employment issued by the
That is rule 67, sub-rule 3, isn't it? That is the only.
Shall contribute to the fund of rupees 50 per annum.
The beneficiary has not.
Just 1 minute, sir. You might have read your brief. My brother might have an occasion to deal with this. I am just have patience. It's an automatic one. Sweet. What more? It's an automatic cessation. If it is an automatic cessation, then what remains?
You kindly take into the provisional consideration.
Please.
Provide that if a registered beneficiary is willing to deposit his annual contribution after cessation of membership,
Correct.
he may be registered afresh.
Correct.
But there is no such opportunity has been given to.
Sir, difficulty is now he is no longer. So you cannot bring it within the purview of a registered beneficiary. If he is not, then how can you? Because it talks about a fresh or a new beneficiary. So that means there is a discontinuance, there has been a vacuum in between. And if he deposits all the areas, then it will be considered as a new one, nothing more than that.
My lord, if the beneficiary has not paid his contribution amount continuously for
3 years.
For 3 years. But my lord, the state has not approved for which year, for which years consecutively has not paid.
Have you shown that my husband or my father has paid that contributory amount for this? Have you? They must have given you a receipt for that.
My lord, I have the identity card. So on payment of contribution amount, the identity card has been issued in my husband's favor.
Show us that you have paid the contribution or contributory amount. They have taken a plea that you have not.
Here. There was no such notice or proceeding.
Whatever, it's not required.
My lord,
It's not required. It's not required.
There is no such, my lord, automatical cessation.
Correct. Let us decide your point. Let us decide. Though the authorities did not take any conscious decision on an application taken out by the appellant claiming a benefit under the Odisha Building and Other Construction Workers within bracket Regulation of Employment and Condition of Service Rules 2002. But in course of the hearing of the writ petition filed by the appellant alleging inaction on the part of the authority in taking the decision, it was brought to the notice of the court that she's a wife or
Wife.
that the husband of the appellant did not pay the contributory amount as mandated under the aforesaid rules and therefore ceased to be the member/beneficiary under the said scheme. A single bench proceeded to dismiss the said writ petition, taking into account the relevant provisions of the said rules, and held that the petitioner, the appellant, is not entitled to get the benefits under the aforesaid rules as the husband did not pay the contributory amount for a period of 3 years, which invited the cessation of the membership as beneficiary under the aforesaid rules. The counsel for the appellant is very much vocal in his submission that the cessation of a membership under the aforesaid rule is not automatic. Even the beneficiary has not paid the contributory amount, as the authority is required to intimate and initiate a proceeding for such cessation. He further submits that the rule further provides that in the event the beneficiary deposited his annual contribution, his membership would be registered afresh, which means that the cessation is not automatic but dependent upon a decision to be taken by an authority. To appreciate the contention of the counsel for the appellate, it would be relevant to quote the provisions contained in Rule 267 of the said rules, amended in terms of a petition dated 30th May 2019. Quote this. On a manifest reading of the aforesaid provisions, on a meaningful reading of the aforesaid provision, it is manifest that the benevolent scheme in the form of a rule framed by the government requires a reciprocal obligation on the part of the beneficiary to make a contribution to the fund at the rate of rupees 50 per annum. It further provides that in the event the beneficiary commits default in payment of a contribution, the contribution for 3 consecutive years, he shall cease to be the beneficiary of the said fund. The said provision, next one, the said provision does not warrant any communication or initiation of a proceeding for cessation of the membership. Stop. We are not unmindful of the proposition that the beneficial piece of legislation has to be interpreted in a pragmatic manner, keeping in mind the object and purpose underlying the incorporation thereof. Beneficial piece of legislation has to be interpreted which would inure to the benefit of the beneficiaries thereunder, and any pedantic view which offends the core intention should be eschewed. The moment the welfare legislation has created an obligation of the beneficiary to make contribution to the of an amount is specified therein, and also contained the provision that in the event of a default in payment of such contribution, the benefits or the membership shall cease, there is no, the conclusion in this regard is inescapable that in the event of a default, the membership ceases automatically. To stop. Any other interpretation to the expression within courts, he shall cease to be the beneficiary of the fund, unquote, appearing in sub-rule 3 of Rule 267, would be opposed to the legislative intent. And therefore, the interpretation sought to be made by the petitioner appellant is unacceptable. The shelter under the proviso appended to this provision is misplaced for the reason that though the cessation may occur automatically on default in making payment of the contribution for 3 consecutive years, yet upon the deposit of the contribution, the said beneficiary may be registered afresh as a new beneficiary. It does not invite a situation where upon the payment of the defaulted amount of contribution, it would resurrect the membership. Stop. However, the revival of the membership may be permissible as appearing in subclause 3 of Rule 267 of the said rules, where the member beneficiary may the payment of the areas of the contribution upon taking a permission of the secretary of the board, who upon recording the due satisfaction in relation to the circumstances which was attributable to a default in making contribution. But such benefit can only be given twice during the lifespan of the said membership, and not beyond that. Admittedly, the beneficiary during his lifetime did not make the payments of the arrears and remained in default, and therefore the cessation of the membership being automatic or default in payment of a contribution for 3 consecutive years, the petitioner cannot avail the benefits arising from the said benevolent piece of legislation. We thus do not find any infirmity and illegality in the order of the single bench in dismissing the writ petition. Appeal sans merit dismissed.
Madam, one more thing, madam. The state has not proved that the petitioner has not paid the contribution amount consequent My lord,
Yes, sir.
my lord, it is the violation of a principle of natural justice, my lord. Without giving opportunity of a hearing, the cessation of members.
Yes, correct. The dictation of the judgment in the open court, the counsel for the appellant submits that the court must also take into account the violation of the principle of natural justice. That is, at the time of cessation of the membership, an opportunity of hearing must have been afforded to the beneficiary under the said scheme. So, a plea of non-adherence of the legal maxim audi altrum partem cannot be taken in an abstract manner, nor shall be applied adjunctly, but must be taken into consideration in the context. Full stop. The provisions which has a statutory flavor clearly postulate that that on default in payment of a contribution for consecutive 3 years, the membership shall cease without containing any provision of initiation of the proceeding, either by making any demand or by initiating any proceeding, the principle of natural justice is not attracted in this regard. The moment the statutory provision invites an automatic cessation, the court should not substitute or add some words into the statutory provision, nor should supplement its view, which would run counter to the legislative mandate, and therefore we do not find any substance in the aforesaid submission. Then dismiss. Yes.
Item number 6.
Correct. Yes, madam. Can you be a bit?
That should be absolutely challenge the order of the Honorable Single Judge.
Where is the order?
That is at Annexure 20 on page 25.
Annexure 20.
Yes.
Can you give me just 1 minute?
Yes.
No, sir. I don't.
Collector's order.
Yeah.
The collector's order It's not never communicated to you. You are party there.
Yes, Your Lordship. I was
Before
there.
the collector, you are
Thereafter-
party.
Yes, Your Lordship.
You filed that.
I have filed the appeal. Your Lordship. I did.
So the order of the order was not communicated to you.
No, it's not in document.
Please read it. These are the language. This is what is. The one point that struck us, because the court has, single bench has dismissed the writ petition only on the ground that she approached or client approached after 1.5 years. Yes. There are a line of judgments which draws the attention. She has not prepared herself on that. That if the grievance or the relief by way of filing a suit can be done, then the writ petition within that period of limitation of a suit, if it is filed, should not be defeated on the ground of delay and latches. Prior to 1950, all these things were determined by filing a suit. It is only after the Constitution is adopted, the concept of writ, prerogative writs from the England that came. But before that, it was a suit. So that has to be they considered in that way. So I can give you some judgments which really runs counter to.
Yes, there cannot be a different opinion.
This
Only
is-
thing is that, my lord.
Sorry, these are the judgments I can lay hand.
2012.
2012, volume 1, SCC, page 66, paragraph 14, 15, and 16. 1995, volume 4, SCC, page 683. These are the two judgments which can be looked into on this principle.
After going
Goes,
to that
let them
improved
go on
order,
merit.
it sucks conscience. After going to the improved order, I don't dispute those things.
1.5 years is nothing.
Nothing that is understood. That is understood.
If it is beyond 3 years,
Yes.
I can understand that he has to give an explanation.
My submission is not that. My submission is.
Can you bring out that judgment, these two judgments which I said?
Actually, she remained absent without informing the authority concerned that she was behind the bars.
Is the merit, let it decide the single bench.
Yes, ma'am.
Automatic
It has not been decided.
automatic
It has
suspension.
not been decided.
Automatic suspension is there more than 48 hours into the custody.
That is
That is, let the single bench decide that. He has not decided on merit.
no merit. He
Only says 1.5 year delay, so dismiss.
delay. Why honorable thing has said, because in spite of instruction by this honorable court in another petition to file an appeal, she didn't prepare an appeal. Thereafter, she was put to notice as to why your services are not
So let him decide. Let him decide on that point. Can you bring those judgments?
How could you come to know about this order?
Your Lordship.
How could you come to know about this order?
Your Lordship, I thereafter, I inquired, like when nothing was happening, Your Lordship, I inquired because repeatedly.
Thereafter, you obtained the certificate.
Yes, Your Lordship. That is why I have obtained a certified copy at a belated stage. Your Lordship.
On the merit, let him argue and let her meet those ones.
This communicated June with the daughter and let's see what happens. They get it. You know, all this here, I let her say about the daughter. They'll tell you, not before they see it today. So it's what happens.
Yes, come. Let us dictate the order. The writ petition filed by the petitioner, appellant, is dismissed by the single bench solely on the ground of delay and laches. It is expressly indicated in the impugned order that though there is no period of limitation for filing the writ petition before the High Court is provided in the Limitation Act, yet the court may refuse to entertain a belated writ petition on the ground of delay and laches. His conduct should not be a blameworthy. Stop. Though the period of limitation is not provided under the Limitation Act in relation to a filing of an application under Article 226 of the Constitution, but the concept of but the principles akin to it, not the concept, the principle akin to it has its equal application when the High Court may refuse to exercise such a discretion vested under Article 226 of the Constitution on the ground of delay and laches. Such principles emanating from a common law principles has been adopted in the Indian judicial the parlance, and its recognition can be seen from the 3-judge bench decision of the Apex Court in the state of Maharashtra versus Digamba, reported in 1995, Volume 4, SCC 683, in the following quote paragraph 19, 20, 23, thereof. Decision rendered by the Apex Court in Leelavanti and others versus state of Haryana and others, reported in 2012, volume 1, SEC, 666. It is held. No, sorry, the two-judge bench of the Supreme Court, upon noticing the constitution-based decision rendered in case of state of Madhya Pradesh versus Bhailal Bhai, reported in AIR 1964 Supreme Court 1006, held that the court should not dismiss the petition under Article 226 of the Constitution of India on the ground of delay and laches if the prescribed period for filing a suit has not expired in the following. Quote paragraph 14. Oh, 15 they have quoted. So much. 14 and 15 quoted. In view of the exposition of law emanating from the above reports, the petition under Article 226 of the Constitution of India should not be nipped in the bud at the threshold on the ground of delay and laches if the same is filed within a normal period of limitation provided for filing a suit on the self-same cause of action. Stop. In case of a suit having filed within the period of limitation, there is no obligation imposed upon the plaintiff to explain the delay, even if such suit is filed on the eve of the expiry of the limitation period. We fail to understand that why there should be an explanation for a period commencing from the date of the accrual of the cause of action till its institution, when on the face of it, it is filed within the normal period of limitations provided for filing the suit on the said cause of action. We thus could not concur with the decision rendered by the single bench in the instant matter. The order is thus set aside. The writ petition is restored to its original file and number. Stop. We expect that the single bench will decide the writ petition on merit.
That's okay.
Mr.
Softly.
Number 7.
So the appearance of the petitioner in which petition was filed challenging the action of the petition utility, placing these transmission lines over the lands of these appealants. Because the original challenge was that there can be a deviation of the plan in view of the adjacent government lands. Now, subsequently, the challenge boiled down to as to whether permission of the district magistrate in terms of section 16 subsection 1 was taken or not of the Telegraph Act, your lordship knows.
You are in caveat.
Yes, I'm in caveat.
The power of acquisition is provided under the Telegraph Act. Everything is there.
Right of usability.
That they can.
Right. And in fact, the consent of the landowners is also not required.
Is not required.
Yes, by virtue of the powers
True.
conferred under section 154 of the legislation.
The district magistrate is getting a power and the compensation he will decide.
Right.
That what compensation can be given. And what has happened?
My lord, that is very fair because consent is not, in fact, it's not required.
It's not required. Because what we were relying upon before the law.
Because that is the power which is conferred upon the authority.
Yes,
That can be
by
done.
virtue of 164.
Yes.
But the only difficulty here, my lordship will appreciate, there's no compensation which has been fixed.
That is a matter to be decided.
So the difficulty.
That does not mean that that really puts any fetter on their part in exercising that statutory power.
They're continuing with us. So it's twofold.
Oh, no difficulty, sir.
It's twofold. So lordship will kind of appreciate. That's the statute provides a mandatory provision under subsection 1 of section 16.
Whether I have decided against him. So now it is up to you. You have to take it.
That's no permission of the district magistrate was taken. Secondly, my lords, no compensation has been paid.
It is not really a permission, but it is an initiation of a proceeding by a district magistrate that
Yes,
he
sir.
has to do it,
Right.
and he can't.
But that
The
is.
problem is my own judgment there.
Yes. Let's here I have been directed.
So I requested my brother, if you can convince him, I can change my view.
His lordship's view there, now it becomes this court's judgment or view.
Sir, this is I would say it has an element of necessity. If that is the thing, then in that event, now the electricity is an essential part of a life.
Imperative in the line is very important.
Is
Public interest.
is imbibed within the concept of right to life.
Right to life.
The only thing your lordship will appreciate is that I'm not on merit.
You are an objector.
I'm an objector.
That is what I understood. That's why.
But I'm the person over whose land the towers being conducted.
No difficulty, sir.
Right.
You will be paid compensation. They will initiate a proceeding for compensation. There is no difficulty.
16 Ps there.
That has not been done. 16
They will do it. They will do it.
But
That's their obligation. They can't shirk their responsibility.
But 16.3 says sufficiency of the compensation, but the compensation has not been determined till now. So
They will. They will. Don't worry. They will. You have to pay a compensation. There's no.
Honorable Singhal just said that you can approve the collector and
Why? That's your obligation
Yes.
under the statute, sir.
That
Why
is-
it should be relegated to you?
that is our duty also to.
So it is your obligation to activate the process of law.
That your lordship will only observe. That is my view.
Brother, nothing more than that. That power is conferred upon the district Where is the portion where you have been relegated?
What should we kindly see? The operative portion is.
Liberty to approach the competent
Yes,
officer.
yes. Page 35.
Show us the section 16(3) of the Telegraph.
So I have a copy of the Bare Act with you.
In view of the century textile just been under the last paragraph is that he go and approach because of safety.
No, that
Maybe
approach is not, it's an obligation.
But 16.3, if I can place it for your lordship. If any dispute arises concerning the sufficiency of the compensation to be paid under section 10, clause D, it shall on application for that purpose be by either of the pleading parties to the district judge within the jurisdiction the property situate be determined by him.
Yes.
Whereas I have been granted liberty to file such an application when the compensation has not been determined, so the sufficiency of which cannot be gone into at this stage by the district judge. But that is a limited grievance.
This is if you come together 10B, please come to section 10B. Proviso D. Sir, that's your obligation under section 10, Proviso D, to quantify the compensation. And in the event they do not agree to the for compensation, then 16B, 16(3) postulates that they have to make an application to the district judge on the adequacy of the compensation, nothing more than that. So, but the stage has not arisen. How can he raise the issues?
What happened?
Yes.
With that,
the writ petition was taken out. You are always typing is taken up. No, taken out by the appellant, alleging the action of the Telegraph authority. No, sorry, alleging the action of the distribution authorities.
This is a state transmission utility.
That's
Fine.
electricity authority. In setting up the poles for the purpose of catering the electricity to the different section of the society without following the due process of law as envisaged under the relevant statute. The single bench, after noticing the various provisions emanating from the Indian Telegraph Act 1885 disposed of the writ petition, granting liberty to the appellant to approach the competent authority for granting compensation in accordance with the provisions contained in section 16 within bracket 3 of the Telegraph Act. Next one. According to the learned advocate for the appellant, the provisions contained under section 16(3) can only be activated upon determination of the compensation under section 10 of the said Act, and does not have does not have an independent footing. Stop. It admits no ambiguity that in order to provide electricity and establishing the tower / the pole over the individual's property, flows from the provisions of the Indian Telegraph Act 1885. Stop. By virtue of there is a provision under the Electricity Act which says that the Telegraph Act powers can be exercised. Yes.
164.
Give that.
This licensing has been given.
By virtue of the provisions contained under section 164 of the Electricity Act 2003, the provisions contained under the Indian Telegraph Act 1885 has been imbibed by way of a specific reference, and therefore the powers conferred upon the Telegraph Authority can also be exercised by the distribution / the licensees. Full stop. Section 10 of the Indian Telegraph Act postulates that the authority may place or maintain the line under, over, along, or across, and post in or upon any immutable property, subject, however, to the eventualities indicated in the proviso appended thereto. Clause D of the said proviso confers power upon the authority to pay full compensations to all persons interested for any damage sustained by the reason of the exercise of such powers, with the rider that the authority shall ensure that the damage is minimal. It is thus an statutory obligation cast upon the authorities to pay the compensation so determined to a person affected or interested in this regard. And unless such compensation is determined or paid, it does not deviate the provisions contained in section 16 within bracket 3 of the said Indian Telegraph Act. The applicability of the provisions contained in section 16(3) is dependent upon the determination and or payment of the compensation, and the person in whose favor such compensation is to be paid raises a dispute on the quantum of the said compensation, for which an application is required to be made to the district judge within whose jurisdiction the property is situated. On the conjoint reading of the provisions contained in section 10 and 16 of the Indian Telegraph Act, the corollary effect indicates that it is obligatory on the part of the authorities to determine and pay the compensation to the interested or affected person whose property is used and utilized for the purposes indicated under section 10 of the said Act. And in the event any dispute over the said quantum is raised, such dispute would be determined by the district judge on an application to be made by such person. Stop. We cannot concur with the ultimate decision of the single bench directing the appellant to approach the district judge under section 16(3), where the eventuality required for invocation of the said provision has not arisen as yet. The ultimate decision of the single bench is modified to the extent that the competent authority would determine the compensation and shall pay the same to the appellant within a reasonable time. In the event the appellant is dissatisfied with the quantum of the compensation, it is open to the appellant to make an application before the district judge as contemplated under section 16(3) of the said Act. Semicolon. On such approach, if any made, we expect that the dispute would be resolved within a reasonable time. So, with such mission, the appeal and applications are disposed of.
My lord. What happened here in the honorable single judge, in fact, he said that approach the competent authority, never said that this judge or any.
Competent authority under section 16(3). If we refer section 16(3), that becomes competent authority becomes a district judge. Has he not quoted 16(3), yes, the matter would have rested there. But he quoted 16(3). That's the problem. That is
clarified.
Yes, that happened.
Yes.
Item number 8.
What page 19? The nature of EIA under Annex 2, page 19, under this central government scheme, Ayushman Bharat Health Mission Scheme, government took a decision to establish sub-health center in all Gram Panchayat level, and place of the establishment is headquarters of the Gram Panchayat. The Lordship have grants to Annex 2 at page 19. Here, the collector Puri the district administration approved serial number 6 that the construction of subcenter building at Baliapada under Puri Sadar block for the year 2013. So Balipada is the Gram Panchayat and head office of the Gram Panchayat is the Balipada. That's why the district collector approved the place that Baliapada. If a lordship kindly see that is thereafter that estimate was prepared and estimate was also sanctioned. And have a glance to Annex 3. All and said, Tahsildar Puri, your lordship kindly see. This is column, the name of the Gram Panchayat. My lord got it. Kalia Kera. This is the village coming under the Baliapada Gram Panchayat. Kaliapada is not a Gram Panchayat at all. It is coming under the Baliapada Gram Panchayat, which is contrary to the guideline. That your lordship kindly see the guideline and it's one.
Can a Tehsildar, DM is in a higher hierarchy of the service, can a subordinate officer
Lordship,
go above the decision of his superior authority?
Lordship, need to give instructions from where, because.
Take instruction. This is the point which struck me.
And
Can he, then it will bring an anarchies, and I do not know what appropriate word can be used in this regard.
Chief, there is also a point there in the Annex 1, your lordship, it says that the subcenter site shall be located preferably in GP. Preferably in GP, headquarter village.
Yes, sir.
Suitable site is not.
Madam, there is no difficulty. There is no difficulty. Whatever is there, if the DM of the district, if he has decided to set up the center, well, sub-center at a particular place, question is whether the Tehsildar, who is below in rank, can he take an independent decision and override the decision of his superior authority?
Why that has happened in Lordship?
There must be a modification by the DM himself.
Or the site may not have been.
No. The DM has to, then it says that I hereby recall my decision or modify my decision or clarify my decision. Abruptly, can the Tehsildar do it?
As to why.
Please consider that. That's the only thing which is struck. If the DM has modified his, this, what is this, order dated 4/9/2023, no difficulty. That is at the top, LT number 4357. Can he?
That also another aspect of lordship kindly Annex 4, page 23. This is the work order. Work order also issued at Baliapada. Now, how the
whatever, let her take a decision. Correct. This is what the point which struck my mind at this.
Absolutely.
So let her take a decision. The instant public interest litigation is filed by the petitioner, alleging that despite the collector and DM Puri having granted administrative approval for construction of a subcenter building at Baliapada under Puri Sadar block for the year 2023-24, the Tehsildar of the police, of Puri, abruptly issued an office letter dated 29/3/2023 indicating that the said subcenter shall be constructed at Kaliakera, which is within the Gram Panchayat of the Baliapada or Balipada. Full stop. The point arose whether the Tehsildar can take an independent decision overriding the decision of his superior officer, to which the additional government advocate prays for an accommodation to take appropriate instruction. When, madam?
On 8th election.
This is the matter on.
Item 9.
Application, interim application, not to proceed with the concession will be completed.
There's nothing.
Then again.
It has completed.
No,
It has substantially come up.
No, they have only stacked the materials. They have not yet.
So the Rome was not built in a day, so it cannot be constructed. We're coming on it. Wait. Don't worry. Yes.
Item 9.
Under item 9, it's in lex, stabilizing lex to customers.
Yes.
So,
Every day the same player.
Yes. Do it.
Item 10.
Item 10, matter for by your
Put-
118.
Oh, 118 ml. Shortlisting. Yes.
Item
Next.
number 11.
May I please, your lordship?
Challenge the corporate demand on proposed notice issued by the Assistant Commissioner of GST and Central Excise Honorable Division, internally alleging it has contravened the provision under section 68(1) and 70 of the Finance Act. This proposed notice was issued on 25/9/2020 and during for the financial year 2014 and 15. So my humble submission before my lord is that by the time this proposed notice was issued, this finance, actual finances are no more there. It is cause of action of 2014 and 15 and also the document does not show that this cause of action survived prior to 1/7/2017 because this act repealed on 1/7/2017 section 173. Section 174 they have not taken that 174 provision also. Now we kindly turn to annexure 1 at page 9. For a moment, page 9 annexure 1.
The actions taken or actions to be taken are not saved
Yes.
under GST.
Yes. Under
They are
section
not-
170 of the GST Act. Yes.
Action taken or action to be taken
Yes.
are not saved.
But here it is a case, there is no document, nothing to be shown that any cause of action prior to 1/7/2017. If you see for section 174, it says, if there is a continuation of
Go and file your reply. You are challenging a show cause and you know the scope of the writ
I know
against
that.
a show cause is very limited.
I bow down that. My humble submission before my
Is it so it is so ambiguous that you are unable to figure out what they really wanted to say? I don't think so. They have clearly spelled that what has happened. You give a show cause saying that this is not applicable or this is something. Why will interfere?
Was this assessment order not served on you?
Yes. I am not on that. Everything is served on me.
We are on that.
Yes, everything is served.
Assessment order was served on you. When?
It is served. It's 25/9/20 is the order. And they have passed the order in original in 23.
You have not furnished complete document.
No, it's 25/4/23.
Sir, you have not you have not given complete document. Page 21 is not the complete document.
21 is not one page left. One page.
Where is that? Where is that page? Have you enclosed it?
No, I not that. That is but it is a mistake from my part. But 25/4 is the date, page 14.
Oh, he has already given a reply.
And we have made a justification calculating all these things.
Thereafter recovery notice.
Okay.
So he's the cap. The outer limit. He has crossed it. Now he is coming up.
Repeated for a flood is so.
I was under the impression he has ignited that the thing that it is a show cause notice which is a subject matter of challenge. But he filed a reply thereafter. I find an order is also passed. The attachment order is also passed.
No, annexure 4 below, that is the reply I have given.
Reply to the referral notice.
This is because representation I have given on in February.
Representation will not do, sir.
But
Unless, Mr. Sarpati, unless you challenge that assessment order, your representation before the authority with regard to recovery notice, will it help you
No,
in any manner?
no.
Reason for such representation.
I submit before the authority saying that.
Go and file an appeal which is time barred.
Yes, my lord. Sir, my submission before my lord is that I am here before your lordship saying that this so-called is a void ab initio, my lord. Proceeding
Why
itself is
you,
void.
after participation?
No, I have not participated.
Oh, you have?
Notice,
Reply.
No, I have filed
File reply.
after this notice. Bank account they have seized, my lord.
So what? You have submitted to the jurisdiction and filed reply. What more?
I have
So,
said that.
Can you approbate and reprobate at the same time?
No, if you see for a moment, annexure 4, my lord, page 24, paragraph 2, my lord. For a moment, page 24, paragraph 2. That pertinent to submit the said chapter 5 of the Finance Act 94 was omitted by section 173 of the GST Act 2017.
You challenge it before the appellate forum.
So,
Go and challenge.
Assistant Commissioner not having.
Sorry. What more?
This is a case if you see section 174 for a moment, my lord. That time this act was not there.
It is there.
No, act was provided there is any cause of action survive prior to
Sir,
that.
174 saves the actions of the
Yes, if you
authorities.
see for a moment 174.
Yes,
But repeal and saving, my lord.
yes, sir.
174 The repeal of the said action and amendment of the Finance Act, as the case may be, to the extent mentioned in subsection 1 of section 173 shall not revive anything not in force. It was not in force.
What is not in force?
So there was no cause of action prior to 2013-14. It is a cause of action of 2013-14. Prior to 17 years, there was no cause of action. Had it been continued from prior to that, then yes, 174 taken.
That challenge you missed the bus.
No, we missed the first minute. Problem is that now
Shall
we have.
not see, sir. Clause E.
Yes.
Clause E.
Yes.
Affect any investigation, inquiry, verification, assessment proceedings, adjudication, and any other legal proceedings or recovery of arrears or remedy in respect of any such duty, tax, such as penalty, fine, interest, so and so, right, privilege.
To be instituted, continue or enforce and any such tax such as penalty, fine, interest, forfeiture, punishment may be levied or imposed as if these acts had not been so amended, repeal law. So my submission before my lord is that this act came into force in 1/7/2017. 1/7/2017 there was no proceeding. So this is a cause of action of 2013 and 14.
So then the clause E has two compartments. One is when the proceeding or investigation has already been undertaken, then it will not be affected by this.
Yes.
Second is that if any liability is imposed for that period, then also for such purpose, this act will not repeal those acts.
Yes, yes, no. That
is something which is there that revives something which was not in force at all, as on the date of the repeal of such amendment or a repeal will not revive. That is this different scenario. E is the clause.
That's why.
If you see, obligation is also.
Yes.
Obligation. So he was supposed to file returns and.
Saving clause really saves those authorities, and then you can't say that it is repealed.
I have
So,
Step, my lord. 174 is repeal and saving.
so whatever.
If you also state-
You missed the bus, sir. You had the opportunity, everything.
So cause notice.
Why you did not challenge when the original order was served upon you?
No, he's a poor, my lord.
He's a poor
Person, my lord, no idea about that. When he had to come to the knowledge from
a
the bank.
poor person doing a business which attracts 9 lakh rupees.
No, it is a contractor, my lord. He's a contractor in a rural area.
Okay.
My lord, he's a contractor in a rural area, my lord. And on Talcher, my lord. He's the range officer.
He must be maintaining the books of accounts, a poor man,
But
and maintaining all the statutory obligations.
when you also see that this
He has that, the
saying,
I would say he is so knowledgeable that he participates in the tender by, so he's a poor man.
Lord, saying this legal provision, we have ventilated our business to the authority to consider.
26 years.
Absolutely.
So let the authority at least decide my case.
Accessible to other.
If he also says he is ready to pay whatever requisite fee is required for appeal, and his case may be considered by the authority. His representation, he is ready to pay because whatever requisite required 7.5 and
Sir,
2.5.
representation will not save the limitation from ticking.
No, I am not with that. I am saying the legal point I raised before.
Representation is not the remedial measure which is provided under the statute.
Yes.
It is taxation statute, sir.
I know that, your lordship, but here my humble submission before my lord is that when the
Can a high court do a thing which is forbidden in law? Tell me.
No, my lord, High Court can say
everything and anything.
Without prejudice,
within the framework of law. And if the law does not permit anything, how can we revive your right of appeal which is lost?
Even if I go in appeal, I have to pay the.
Can we revive your right when the right is lost? Tell us. Give us one decision of the any court.
I am before your lordships to satisfy.
Can we do it? Tell us, sir. You are an officer of the court. Maybe arguing for your. Tell us the law. If you can say that this power is there, we are ready to exercise.
If your lordship see that an impugn demand comes open, they have not invoked 174 even.
Sir, I understand.
But without invoking 174,
your right of appeal, if it's there, can we go and say that now, even if the right to appeal is lost by virtue of the operation of the statutory provision, we are directing you, revive. Can we do it?
But your lordship can say, my lord, when they should have invoked 174, my lord. In the so-called, they have not invoked 174. If you also see the so-called, it itself is illegal.
As an appellate court.
Presentation.
I am
It's a revival of.
I am not an appeal, my lord.
Period of limitation, it does not apply.
My
brother has already got.
Okay. There is a legal point, it has to be answered.
Yes, already decided the legal point. Which one?
Should we give him chance or
What chance?
I say they requesting the withdraw and file appeal. Whatever the otherwise it will be against him. Suppose your lordship held that
No, this reply he has sung against the recovery notice.
Recovery notice not solve
This
this
representation will not.
because the notice has already marched with the order. Now we cannot challenge.
Now, why should an authority consider a representation which is not within his purview to consider?
Law is like that, he is the judge of his own. Assistant Commissioner, he is the person who is issuing notice and he is the person who has passed the original order. This law is like that.
So that is the taxation law.
It is an expiry order also. It is an expiry
Assessing
order.
authority is
That's why I humbly
adversarial jurisdiction there.
It is an expiry order. I am ready to pay whatever requisite fees,
Principle
Lord.
which you just propagated, a person cannot decide its own cause. His principle is not of an absolute embargo.
My submission is an expiry order, my lord. I did not get opportunity. The lawsuit is bread and butter, my lord. He lost his.
My brother has asked you a very pertinent question. What do you want? He is going to dictate. He has dictated it. What do you want?
I pray your lordship, please allow me to attend there, and I am ready to pay the fees, my lord. Whatever.
Then my brother has already
Now-
dictated.
What your colleague Satpathy has suggested. If you wish to, then we will.
If I withdraw,
Then-
my lord.
That will create a problem to you. Don't worry. So decide it.
We'll decide.
Yes, decide.
We will decide, then I'll.
Yes.
This-
That's true. I will to mention your some 16. I will talk to 2 plans. I may permit to withdraw the restriction with
My
my
brother.
to find a better application because certain grounds I left, my lord. I don't know, my lord.
I have wasted then.
Yes, my lord. I am sorry for that.
No. I have already.
But 63 4G I have left, my lord. I will take that.
I
It's a batch of
skipped
cases.
my lunch.
My lord, batch of cases are there, your lordship.
Now, once the dictation has come.
It's all right.
I forward.
Item
Yes.
File a better.
17.
Permitted to withdraw.
With the liberty to file better application.
Better?
Better
No.
application.
No better application. Permitted to withdraw to approach appropriate forum.
Appropriate forum, liberty is granted to approach appropriate forum with a
No
consider
further.
my
No further.
application be considered accordingly. Limitation application.
That
And you also
you avail the alternative remedy.
apply with the limitation application that be considered.
That you file.
Your lordship.
Section 14, whatever.
I'll approach the
Only permitted to withdraw, you file memo of withdrawal. So,
yes. Permit to withdraw, liberty to approach the authority.
appropriate authority.
Yes.
In accordance with law.
Yes.
Items.
I have also this item 9.
Yes, let us. You miss the bus. Let the others who are waiting.
I have passport lordship. My lordship will agenda after vacation lordship.
My brother has already
Doing
done.
purpose,
Yes,
right?
next.
Lordship, it will be
Items.
lordship otherwise.
My brother has already passed.
There perhaps no other lordship because lordship
My
otherwise.
brother has.
Adjourn कर दो.
After vacation it is when lordship.
After vacation now, ये पे time नहीं हो.
Urgency lordship, if it is not taken up today, it will be infructuous lordship.
कौन करे? काली को थिला जी पूरा.
In fact, lordship, yesterday also I am making a mention to take up this matter.
But you did not appear when the matter was called.
No, his associate mentioned.
No, that's
that
true.
he
He
was-
did
he
not
was on-
appear.
Not lordship, I was in late lordship. Because lordship, I was not bothering lordship.
This was so important. If this was so important matter that it cannot wait, then you should have.
Every matter is important for lawyer lordship. I was in my legs lordship, I was interested in avoiding
Convince
support.
my brother who has already passed an order.
But lordship, I am extremely sorry lordship, I can say lordship.
Convince
with
my
great
brother.
effort,
Convince my brother.
I am convincing lordship.
Yes,
both lordship.
let him.
Because lordship, otherwise it will be infructuous lordship. Yesterday I was making mention.
Let him. You convince him. He has passed the order. Yes. What you
By the legs lordship, matter was going on there lordship. So definitely I respect to court lordship.
Oh, true.
First over.
Please.
First over.
Grateful.
Item 17.
May I please please. Can we take up the additional affidavit? The additional is a flag beam. What has happened in this case about a brief background, my lord. Here, my lord, the petitioner,
Yes.
here the petitioner, my lord,
was accepted.
operates in Orissa, he operates in Chhattisgarh, and he has his head office in Haryana. And so far, it's a PAN-based system, my lord, where he accounts are kept in Haryana, my lord. But he has 3 independent GST numbers, one in Orissa, one in Chhattisgarh, one in Haryana. my lord.
Then what is the law?
So-
Are you not? Then what is the law? Are you not supposed to maintain the records
No,
within
it's
every independent?
it's
Three different.
a PAN-based record, my lord, where all my accounts are maintained.
Then
at
why
Haryana.
the one GST would have been sufficient
No,
for you?
because since I am working in 3 different places, I had maintained 3 different.
So you'll have
What
to
the
maintain
authority-
three
No,
records. And the Pan India will be a
What has
consolidated.
happened in this particular case, my lord, is
Hmm.
I have shown my Orissa figures. I have shown my figures for other states. But unfortunately, what the officers have done so far as Orissa is concerned, they have taken the all India figure. And especially when they have noted, I'll demonstrate that before from my additional affidavit and from the order itself. They have noted that my Orissa transaction is X. My all India transaction is Y. And what they have taken is X plus Y. And they have raised a demand. That is number 1. Number 2, my lord, they say that no documents were produced. The very, my lord, show cause, right up to the from the date of the show cause, I've given all the documents. It's a part of their show cause. All my documents are there in the show cause. Still, my lord, they write in the order that no documents are produced. So we proceed, my lord, as if no documents have been filed. Third issue, my lord, so far as this Chhattisgarh transaction is concerned, the officer, my lord, he will not transfers this to Chhattisgarh for assessment. The Chhattisgarh people, they assess me, they drop that thing, my lord. But unfortunately, that figure is also added here as a part of my already figure, my lord. So basically, my lord, these are 3 allegations which are telltale, my lord, on the face of the record, my lord, which is erroneous.
Third one.
And
If the Chhattisgarh authority has dropped it, how can we include it?
We have to verify what have been done. That can be done only by the assessing officer only.
Whatever, if those demands are found to be untenable, then why you will include it?
Mr. Kara, take me to that part where they have said that you have not produced any record.
Sorry?
Take me to that portion where the authority has said that you have not produced any record.
Your lordship may kindly turn to 65 notes.
65.
Page 65 with order notes. It's annexure, the running page 65. The annexure, justice.
Annexure?
No, page 65 with a part of notes, annexure 4 notes.
4.
Month. Running page 65 note begins at page 27. Paragraph 5.5 notes. Internal paragraph 5.5 notes at page 65.
5.0.
5.5 notes.
Which page you are referring?
Page 65 notes.
That's not a
87. Computer page 87.
I think that
Mr. Pedia, come to page 64. Come to page 64. Yes. Can you read the table?
The Odisha, other than Odisha.
Sir? And within that table, what is that table? Sir?
Cancellation figure taken in the Soko's notice.
It's the legible one. Nobody can figure out the second one.
Is it an order passed already? Huh?
It has been passed by additional commissioner.
Assessing authority. Can he read this? He has served it on the assessee for whom he has written this.
This may be verified by the original.
That is what he has been supplied. And when you have mixed up and Odisha figures, the entire Pan India figure in Odisha assessment, so you have made this mess also.
And the lordship would appreciate it. Page
Then Mr.
Page 63, if the lordship may kindly turn. 63, my lord.
63.
He quoted, my lord, this, my lord, if the lordship would kindly say transportation, loading, unloading, stacking charges. From the table, your lordship would see location Odisha.
Yes, other than Odisha.
Other than Odisha. Total is 891, 692, 266. What he has done, my lord, is the lordship would take up my additional affidavit. It's
no, first you
clarify
that.
At page 70, if the lordship would kindly say.
In 65, At 65, you wanted to show that.
Yes, my lord. Page 65.
Hmm.
If your lordship would pick up my additional affidavit, there, my lord, that page, the running page, my lords, Annex 6 at page 7. This is a part of the show cause notice, the documents which they are annexed, my lord. Additional affidavit at flag B, page 7 of the additional affidavit. Your lordship may see serial number 10 and 11, my lord. Copy of the reply of the noticing dated 7/7/2022. It's a part of the show cause, which is Annex R.
Additional affidavit.
At flag B, my lords.
Flag B.
Internal Annex 6 series, internal page 7. The serial number 10 and 11. No, this is a part of their annexure in the show cause.
Copy of reply.
Copy of the reply of the noticing dated 7/7/2022. 11. Copy of the balance sheet for 17/18, 18/19, and 19/21. And my lords, your lordship would see the reply which I have given to her, which is also a part of their show cause at page 8. And this, my lord, what they have done, my lord.
No, have you already given the apart from auditors, chartered accountants, audited certificate?
That's at page 9, my lord.
Is apart from that.
Apart from that, your lordship.
Have you given a primary evidence like a detailed ledgers, trial balances,
that is at page
returns?
That is at page 9, my lord.
Then transportation and the loading and unloading, legal and professional fees, security expenses.
My lordship, kindly turn to page 9.
All attachments.
Page 9.
There. So I just wanted to have it.
Page 9.
Then 5.5 is wrong that these documents are not filed.
5.5 is wrong. And my lord, what he has done, my lord, virtue of the NCLT orders, my lord, this company with effect from 2nd of February 2021 has merged with ACB, which is the holding company, my lord. What they have done, my lord, they have also taken the figures of the holding company for that last year, and they have included it in it. And that is the document which I have also annexed, my lord, which is a part of the show cause in my additional affidavit. If your lordship would kindly see, my lords, for a demonstration, my lords, I tell them that this has from 18th of February 2020, by virtue of the NCLT New Delhi's order, I have merged with the holding company.
The scheme of amalgamation was approved in the NCLT. And what is the effective date which you are declared in the amalgamation?
18th of February 2022. No?
The effective date there, it should be there.
It is there, no? And what they have done, my lordship, I kindly turn to page 12. They have taken ACB, the holding company's figure, and included it in my lord. I've given that, no? Your lordship would kindly turn to page 12.
How can it be done? It's can't. How can that be done?
And
if the effective date of an amalgamation or the merger is already indicated in the scheme for amalgamations, then prior to if the effective date of a merger is already provided in the scheme and the scheme has been approved by the NCLT, then in that event, prior to the same, the effective date, can you treat it as the merged company or amalgamated company and then show it?
In this issue, the only matter relates to RCO.
No. There are three heads of demands. Transportation charges.
Transportation on
RCO.
Could you follow what my lord has posed a question? Insolvency and bankruptcy code. Is it not in operation? Merger.
The old 384, 383, 384 proceedings. Scheme for amalgamation. Both the companies, then they can agree to merge with one company, and the scheme of amalgamation is already filed. Now the shareholders meeting and everything, and it is resolution is passed for merger. Then the scheme must indicate the effective date of the merger. If the effective date is already given, from that date it will take effect. Then anything which is done prior, it was done prior.
Sorry.
This transaction is prior to the effective date or after effective?
18th of February.
And these are prior to effective date or not?
After, they take the entire period of 1920 minutes to demonstrate the lordship.
And what is the effective date?
Effectively 18th of February 2020 minutes. 2020.
So it's prior.
It's
Some portion prior and some portion after.
And if your lordship would see minutes, they picked up ticket. If your lordship would kindly turn to page 70 of the brief.
Normally, in the mid of the month, effective date is not given.
No, normally
It is always at the end of the financial
but they have
year.
taken it. So far as NCLT is concerned, they have given it. Your lordship may kindly see page 70. If your lordship would see, I'll demonstrate it from the balance sheet itself. Page 70. If your lordship would see one figure of the brief. Paragraph 5.10. Your lordship got it?
That is page 70.
Page 70, paragraph 5.10.
Yes.
Therefore, as per the balance sheet and expenses made by the noticee under the transportation so and so 1920, your lordship just marks the figure 358848.
Yes, whatever.
Your lordship will kindly turn to page 12 of my additional affidavit. This is the figure of ACB, the holding company. Page 12. There, under the heading of transportation and loading charges, serial number Roman 4, lordship,
12, yes.
Page 12.
The underlying transportation and loading charge.
3588.
This is the ACB India Limited.
Minus 358884.48. The same figure, my lord, they have kept it at page 17.
Normally, it is always just at the end of the month. The company merged with the another company, then all liability, assets and everything is imposed upon the transferring company.
But
Transferring company, that's a transferring company, it becomes liable. And the existence of the transfer company is no longer
but ACB
alive. Now it becomes a responsibility of the transferring company, ACB.
The ACB, my lord, he is assisted Haryana, my lord, Gurgaon. He's a registered dealer in Haryana. So figures are and that
the operation
part so far as Orissa operation is concerned, they have 3 states.
So this is the ACB's operation.
It's not, my lord. A lot of you would see, had that been the case, the Raulkala authority would not have transferred a part of it. If the lordship would kindly turn to pay Annexure 5 series, what they have done, no?
No, that is a different issue. When you talk about that it is the ACB's, I was just thinking about it that why not? Because the transfer company has gone.
True, my lords. But ACB having once been assessed at Haryana, my lords, he can be assessed for the same figures at Orissa.
Are you not, the ACB is not using and utilizing the GST number which was given to a transfer company?
Great respect, no. After the merger, no.
No.
And if your lordship would see,
give your response, sir. We want to hear. This is something which is really complicated, and we want to hear everything.
I'll
give your response to.
And your lordship would see, demonstrate.
This creates a anomalous situation.
Yes. And so far as Haryana is concerned, so far as Chhattisgarh is concerned, Annexure 5 series at page 183, the self-same officer, my lord, he gives this particular transaction. If your lordship would kindly see page 183. Annexure 5 series. This is addressed, my lord, to Chhattisgarh.
Give 183. Yes.
This is addressed, my lord, if your lordship would see. So and so.
Paragraph.
Chhattisgarh. If your lordship would just turn over the page. Paragraph 3, my lord, that's page 184. 184, my lord. Page 184, paragraph 3.
Running. Where is that?
Running page 184. paragraph 3, my lord, an email sharing of information in relation to evasion of GST.
Yes.
Dated 23/5/2023 from GST and Central Range Rourkela Commissionerate, Civil Township, Rourkela, containing letter number so and so, dated 12/5/2023, accordingly to which an investigation was initiated by the Rourkela counterpart of the noticee, GST number so and so, for not discharging a GST liability of 9 crores during the period July 2017-2020, and the RCM based upon the data submitted by the noticee for its units located in Orissa. Observing the practice of the noticee to evade from payment of taxes against the services received in relation to the transportation of goods in case of coal, the Rourkela counterpart shared the information to verify the issue in the state of Chhattisgarh and take action accordingly. Based upon the shared information mentioned in para 3 above, the officers of the Central GST and Central Excise CORAM, on being authorized for inspection of the noticee by an inspection note number so and so, DIN number so and so, dated 24/5/2023, issued by the Additional Commissioner Preventive, Central GST and Central Excise.
So this was prior to the period.
No, the same
prior
period.
to the order of merger.
Same period, tax period 17-18. A lot would turn over the page. Sorry, I would turn to the
That is
previous.
before the merger.
That was I was just talking about this particular aspect.
What my lord is asking is, these transactions are before the merger.
No,
And that cut off.
Merger,
That is what.
merger is one of the issues. So this is a second issue where after having transferred it to Chhattisgarh, and after the Chhattisgarh people, Lord, they have not dropped demand, because at page 1217, Lord, the ordering portion, the proceeding initiated under show cause issued by so and so, dated 1/8/2024 for demand under the GST and reverse charge mechanism is hereby dropped on the reason as discussed above, Joint Commissioner of Chhattisgarh. And they have not incorporated this again to my demand also. So
Let them give a response.
But let me take instruction in this. 2 weeks time.
Why?
Because these are all the figures and I have to take, they have to give us the data accordingly.
Or otherwise, my lord, this matter may go back to the officer, let him apply his mind and to cut short, my lord, the delay. Because now, my lord, this company is no more in existence. I'll be only carrying on this liability so far as Orissa operations are concerned.
That is one of the conditions of the merger scheme.
Now
You have to carry the liabilities. You can't escape from the liabilities. Look at this, the sanction of the scheme of merger. There's the voluminous documents that contain that clause.
But if it goes back, no, the matter can be resolved easily. Because let him go through the figures, let him analyze it, my lord, and having noted, my lord.
Let them come with the instruction. Let us see. Then we'll definitely take care of that. These are the anomalies which he has pointed out. That has to be looked into. Why 2 weeks? Why not a week? Why not a week? Why 2 weeks? Why not a week?
And lots of it's a figure matter and it's involved lot of amounts that it will remind back to the additional commissioner and all. From law department, it will go to them and they have to verify and give the counter and all this. It will take 2 weeks lots.
We have to simply say that how can you include those and what are the reasons and why it has been done. These are the matter. They will be able to advise you immediately. It will not take much time. He has seen the point of objections.
The assessing authority is fresh in his mind what he has done.
It will take time, let's see.
No, if we are keeping this matter after a week, and in the meantime, you just take instruction. Consider that. Keep it on 8 or 9 or whatever.
8.
Keep it on 8. Yes, this total was passed much earlier.
No. Sir, I've approached your lordship, Lord.
When the order was passed.
February.
29.
So 1 week. If from February nothing happened, then for 1 week.
Mr. Kedia can
Yes.
My learned friend.
Yes, sir. If you.
Item number 18.
Tax department, I could have assured within a week.
Whatever you come within a week, ensure.
Keeping to the night.
Mr.
Eight.
Nine.
Mr.
Eight.
Senior advocate submitted that the assessing authority has taken into account the figures relating to Pan India instead of restricting the figures with respect to transactions affected in the state of Odisha while computing the tax liability. He further submitted that though all the documents, including books of account and audited accounts, have been furnished to the assessing authority, the observation made in the assessment or order in original that the petitioner did not substantiate the claim by furnishing documents is not in consonance with the material available on record. Mr. Avinash Kedia appears pursuant and seeks a week's accommodation to obtain instruction. Place this matter on.
Eight.
It's
What's your pleasure? Learned friend, just put in a word,
Item number 18. Sir.
Time for the petition, therefore the petition is under income tax.
Delay of more than 2 years.
No,
800 and something.
no, your lordship, your lordship.
886
No, your
days.
lordship, that has been found out by
And
the only 65 days this. Let me convince your lordship. There is only
65 days
your
delay.
lordship. Your lordship may kindly turn to my list of events.
They said that the order was duly served on you
Your lordship.
11/12.
Your lordship, the delay has been condoned by Honorable Supreme Court. If Honorable Supreme Court's order will be considered from 15th March 2020, 28th February 2022, as per the Honorable Supreme Court's order, this period is considered
to be excluded.
After that, within 90 days, the appeal should have been filed. So before Honorable Supreme Court order, there was delay, only 65 days delay. Your lordship, 886 days delay is the total delay.
Now tell me when the period of limitation expires in the month of January 2020.
Your lordship.
When the order suo motu proceeding was initiated.
Your lordship may kindly tell.
When the suo motu proceeding was initiated.
Your lordship,
in the month of March 2020, what was there?
It is
where the period of limitation falls within that mischief period. Those would be excluded. Those which already
Your lordship, it is
expired prior
the order. Your lordship, it is a mercy petition, your lordship. Why mercy petition? Before passing the order, assessment order, the petitioner was in the custody in a false case. After returning from the custody,
so that created a psychiatrist problem.
Exactly.
Problem.
Exactly.
There is a medical prescription.
Your lordship, all the medical prescriptions have been included in my condonation of delay application before the. So it is for your lordship to consider.
So you were not in a position to do the business.
Your lordship, now in the meantime, it is just starting. It is beginning, your lordship. Your lordship, only I can understand your lordship's mind. Only your lordship also under VAT Act, since there is no upper limit. Also first, I am not relying. Only I am submitting your lordship's mind. Your lordship, this case is required to be considered legally.
How much is the amount levied on you?
Your Lordship, the amount, the ex parte order, 144 under section 144, 7 crore 70 lakhs, Your Lordship, is the demand without being non-appeared before the assessing officer.
That is the addition.
This will
That's
apply,
the addition, Your Lordship.
this will apply when you appear this side.
Your
If you
Lordship,
consider-
Your Lordship, since there is no upper limit here under Income Tax Act section 249, 2 and section 249, 3. For that reason,
There is a pragmatic view, the reasonable value that is to be taken.
Your Lordship,
Depending upon the nature of the explanation, it does not
since
mean
there is no upper
that
limit,
everything.
since there is no upper limit here.
So 886 days.
Your Lordship, only that point of Honorable Supreme Court, Your Lordship.
Show us that whether it applies.
Your Lordship,
Can you take advantage of that? Show us.
I have got to.
First order you bring, that orders.
That order is that please 70, I can understand, Your Lordship.
So
In cases where limitation would have expired
during this, then, and which expired prior, then.
Your Lordship, for
Where,
that
where
reason-
is that Honorable Supreme Court, I think,
No, the explanation,
I've enforced
that
that
may be an explanation that, yes, there was a delay, and then you explain, and then you take a plea, the pandemic intervened. Though I was very much ready, but I cannot because of the pandemic. Whatever, blah, blah, blah. But that will be a reason, but it does not mean that it will lower down the number of days.
Your Lordship,
Days would be counted 880.
But I've also considered in a pragmatic view, Your Lordship, because also those total 2 years period.
When you suffered the psychiatrist problem or a mental problem,
Your Lordship, the mental problem, Your Lordship, during the period, my condonation of delay application.
no, he has quoted the whole application.
Your Lordship, that is also at page 45 and 46, my delay application. Your Lordship, there is also some fault, Your Lordship, I should not say like this, but some fault also
Page,
on the part of the authorized representative, 45, deed and authorized heir. I should not say like this, but unfortunately, this is a matter that everywhere it is ex parte, Your Lordship, 144 assessment, as well as the first appeal is delayed. Your Lordship, since both the matters is the assessment is also ex parte 144 base judgment assessment. But that is in Your Lordship, my.
where is the medical prescription?
Your Lordship, I have not.
It is not annexed.
Your Lordship, let it, day after tomorrow, I will file in affidavit. Your Lordship, all these have been enforced at page 47.
But you have not pleaded the case of a pandemic.
Your Lordship, for that reason, there is some lacuna on behalf of the petitioner's counsel, your petitioner's heir, Your Lordship. It is admitted, Your Lordship, because in my part, my application is for condonation of delay of 886. Only I admit I have developed this so as the pandemic issue here, Your Lordship. It is admitted, Your Lordship.
Lordship, page number 60, he has filed a condonation petition without any documentation. For that reason, this has been.
No, he says the medical prescription is filed.
That has been enclosed.
That is paragraph 5 of the condonation application.
Lordship, page number 65.
Page
Adjudication.
Now, page 47
Page 46.
enclosed affidavit medical prescription.
Let him produce all this document, Your Lordship. Unless until you won't produce the document, it has been, this condemnation has been rejected on the ground only in absence of documentary evidence, and it didn't appear also.
That is what.
At page number 60.
That is what paragraph 5, I find the medical prescriptions and everything
Yeah,
is there.
And also enclosure as page
It
47.
has been written
Enclosed,
about the assessing of where the appellate authority find out that it was not there. Maybe
Where is the medical prescription which you are
I
there?
have not enclosed here.
Enclose it,
Your
bring it, consider.
Your
When?
Lordship, Next Monday. Next Monday.
Monday, next.
12.
Good.
Item 19.
The question in this case is raising the notice issued under section 148A after insertion section 151A, and a batch of matters have been admitted in this matter. And secondly, the question of the order, reassessment order is being sought without considering the replies filed.
Main case is the Dalmia Bharat. Main
Dalmia
case
Bharat
is the main case.
is the main case. I have flagged up.
Siva Summon also 27670/2024. Lot of cases have been. As can be
We'll have to keep it.
No, there is no date fixed.
I have to verify. Probable it has not been. I have to verify what.
And we will fix one day after the vacation, whatever, and then we will decide this one. All the batch should be listed.
15th June.
25th June,
No date.
25th June.
Yes.
Along with all the connected matters.
Item number 20.
This is one of the better drugs, is similar to a batch of red petitions, where those are pending for your active bills. The case of the petition bills. The order bills is passed.
What is
with
that? What order has been passed is a batch of petitions.
168A, there's invoking power under 168A bills. The state of limitation is extended, both by the state notification and central notification. And that 168A presupposes recommendation of the GST Council. Because even though previous notifications are supported by recommendation, but the last of such notification which extends for the period of 1 month until there are 30th April.
That is pending.
Yes. Absolutely. The last of such notification.
Force measure.
Now the Supreme Court has also decided how to interpret force majeure clause during the pandemic and how it has to be done.
Other high courts are also decided in favor of the revenue. In favor of the revenue.
No, not in force.
Notification.
This is for the period 18,
In the notification, they have amended.
Yes.
In the notification, which is a conferred power, it is a conferred power under 168A.
Yes.
That in the notification, they have initially fixed the date within which the force measure would apply. Thereafter, they have substituted that date.
No, so far as 18, 19, because for different periods, different limitation is also there. Date of limitation also different for different periods. Your lordship in this petition concerned for 2018-19. Because I have annexed all relevant notifications, and the last notification, may I start place from the beginning, it will clear. Kindly see.
Similar matters are
If the similar matters are pending,
Yes,
we
yes.
tag them, let us hear out that.
23rd June, the petitions are pending. These petitions must have been tagged in that. The number 27,073, 2024.
That is the lead case.
Lead case. That has been fixed on 23rd June 2025.
So let it also appear on that day,
Your Lord.
23rd June.
Your Lord.
There is no reference here.
No,
Give it in it.
Your Lord.
They slipped.
I have given 2 orders to lordship.
Yes, similar order will be passed, but this matter will be tagged to that matter which Mr. Mishra says.
It is for 18-19.
Wherever 56 notification is
We
there,
will decide the principle, Mr.
Principle, but the principle so far as
Each case,
18-19 concerned bills, we are very specific, we have case of the petition that we have recommendation is sine qua non to grant of limitation, invoking 168 bills. In all other cases, recommendation of the GST Council was obtained prior to issuance of notification. But the last such a notification which has extended at page 69 for 1 more month belongs. Whereas then there was no sign of any COVID or anything. So they went on extending belongs and again they re-extended once again for 1 month without a result and there was no recommendation. So therefore, they have your lordship directly file counter affidavit.
Let me clarify in one line what is their argument. That is, their argument is that without recommend, as per section 116,
Without recommendation.
without recommendation of the council, GST council, this notification has been issued. Our argument is that this notification has been issued, which has been ratified by the GST council. So whether the ratification is right or wrong, this is to be decided by your lordship. That is the case.
That query was also raised before the Honorable Guwahati High Court, and no answer could be offered by the council for the state minutes, and the review petition was dismissed minutes. So it's a ratification.
So let us come on 23rd.
Yes. Same order by kind of
Yes.
Deep problem.
The number that
Give a number.
That's noted.
the same order to have.
23rd of June.
Yes.
এটা যেটা অর্ডার হয়েছে সে পরীক্ষা দিয়েছেন সেম অর্ডার নদিব লিস্ট দিস ম্যাটার along with সেই যে কেসটা দৌড়ଛନ୍ତି সে স্লিপরে দেবে ହେଲା সেই ম্যাটারটা লিড কেস করতে এইটা তাকে ট্যাগ
Yes.
দিলেন মিস্টার
The lead case proceeds.
হ্যাঁ এই কেসটা দিলেন স্যার
Item
Lordship, in that case, all the numbers have been tagged. So let all these cases on 23rd 6.
So it will come. You just give a number. It's called the name.
yes, madam. Item
what is the order is the same order will be passed as Mr. Saul has given that copy of the order that will be same but this matter will be tagged all that matter which you have given.
Mine.
That's all.
Mine.
item 21.
Give the order. The covered one
No, madam.
is not a covered one.
It's not covered.
Cancellation of your registration.
No, you.
This is refund your lordship. This is 21, madam.
22 is covered.
Oh. What is the? Yes.
Madam. The question of law for determination before my lord is that whether supply, installation, and erection of solar power generating system is a composite supply of goods and services. Is a composite supply of goods and services falling under subsection 30 of section 2 or a works contract falling under subsection 119 of section 2 of the RPO. Because the rate of tax is different in case of composite supply and works supply. The order passed under section 107(11) of the Act, your lordships, with regard to determination of tax, your lordships. The petitioner has entered into a contract on 7th of
you are challenged Annex 11.
Yes, my lord. Annex 11, page 113, my lord.
So against that alternative remedy is there.
My lord, I am against the order of the first appeal before you.
First appeal. So you pay 10% and the same thing.
The payment is not required.
Not the required or refund.
Rejection of refund. So only it is to be admitted.
Tagged to that. Only tagged to that. En bloc will be against the order in Annex 11.
My lord.
Alternative remedy is provided under the statute. But since but as yet the GST appellate tribunal is not functioning, is not yet functional. Therefore, this matter therefore issue issue notice. Issue notice. List this matter along with select number
9822 of 2020.
9822
of 2025.
2025.
23rd June 2025 is the next case. 23rd June 2020.
List on that day.
23/6/2020. Yes.
Item 22.
appear court something number ta dekri ଆପଣଙ୍କର ନାଁ ଗୁଡ଼ା ଲେଖିଦେଲେ ସୁବିଧା ହବ ସେ ଟାଇପ କରିଦେବେ.
Lordship, the cancellation of affidavit. Submit to one, submit to two.
So proposal Chittaranjan Das. Yes.
On the next.
Item 23.
Wait, the subordinate. The petitioner SSC,
Yes.
which you are not see, is a SSC in the state of Orissa is regularly assessed at Telegraph. He has obtained the card, which is annexer 2 to my petition at base 55 lines. He is also assessed that assessment order is also for the period for the assessment year 14-15 matters may be pleased to see at annexer 4. The matters shows the position on 29/1. I'm saying the cause of action then. 29/1/2021, a search operation took place with the SSC and also a group. Now, this group, as per the CBDT notification, was centralized and the Calcutta, Central Zone Calcutta, and giving that notification to your lordship's kind notice, annexer 7 at page 101. I'll place it matters. For a limited purpose, the complete the assessment proceedings under section 153 capital A that prescribed for the search assessment to be conducted. And that was this petitioner file was also transferred. 101 is the order of the PCIT Sambalpur. I'll place that matters. Annexer 7. They asked me a letter whether I'm inclining. I said no problem. And
So it is transferred to DCIT Central Circular.
yes. Thereafter, my lords, the assessment order for the period 16-17 was passed accepting my return. That is search assessment. That is annexer 5. My lords, may you please to see at page 97. I bring to a kind of lordship, may you please to see.
It's a search and seizure operation under section 132.
132.
Yes,
and thereafter, this has to be made under section 153A subclause 2. And there, the assessment was completed accepting my return.
Yes.
Yes, my lord. Lordship may be pleased to see annexer 5 at page 97.
Yes, we have seen that.
Thereafter, my lords, at the time of search and seizure operation, all my documents, everything was seized and they completed the assessment, search assessment, which my lords have been pleased to see. Thereafter, my lords, after the search assessment, the OP number 1 assumed the jurisdiction in invoking the power of reassessment that is prescribed under section 148 capital A, that is the new regime of the Income Tax Act. There he issued a show cause that so and so information has received 148 capital A, there are steps, has prescribed 3 stages. How to first issue, how before issuing an order, notice under section 148 for reopening, what the assessing officer is obligated on his part to do. And first I bring your lordship shine notice to the notice issued to be issued under clause B of 148 capital A. Yes. Small b, clause B of 148A. Provide an opportunity of being heard to the assessee by serving upon him a notice to so cause within such time as may be specified in the notice, have being not less than 7 days and but not exceeding 30 days from the date on which such notice is issued, and such time as may be extended by him on the basis of application. In this behalf as to why a notice under section 148, that is the triggering point. Issuance of notice under section 148 is the triggering point of reassessment. That's the triggering point. Whereas before that trigger is pressed, these are the procedures to maintain. What happens? C. Consider the reply of assessee furnished, if any, in response to the so-called notice referred to in clause B. Then, my lords, comes the final. What happens? What is there, my lords? Clause D, decide on the basis of the material on record, including reply of the assessee, whether or not it's a fit case to issue notice under section 148 by passing an order with the prior approval of the specified authority within 1 month from the end of the month.
Which one is given? It is not telling what he is reading.
Is
Beg your pardon, ma'am? It's not telling.
Unamended.
footnote.
No, he is reading unamended.
Unamended.
But that also does not talk about the period of 1 month.
148A has been amended.
You know, so that has been amended recently.
Ah.
It is prior to that.
Yes, because the assessment
So you,
1516. Yes.
all that we are getting confused.
Yes,
That's the
sorry, madam.
new act has been taken.
Yes,
That new act has been amended.
I'm reading the earlier provisions.
No, where is the period of 1 month? It is even an unamended.
The question is, my lords, I'm not on this 1 month or 1 week, nothing of that sort, my lords. I am on the question.
No, I got your point that
Yes.
before you initiate any proceeding under section 148,
Yes.
these are the obligations that you'll have to give a notice which is not a 148 notice,
But
calling upon him to give an explanation and then reply and then consider and decide.
And opportunity of
Decide that why 148 notice should not be issued upon. I got your point.
Now, my lord, will be pleased to see. My point is that I made a reply. The lordship
Pursuant to 148A.
that so-called notice, clause B 148A, that so-called notice was giving the annexer that on certain information.
Whatever, yes.
Yes. Then I gave the reply. That is annexer 10 at page 111.
Annexer 9.
Annexer 9, sorry. I
Yes.
correct myself. Annexer 9 at page 105.
Yes.
My lords may be pleased to see that reply. I not only refuted the allegations, but also it starts from 105, annexer 9. Thus, you may be pleased to see.
Yes, yes.
Then, my lords may be pleased to see. Para, in my reply at page 109, it is a well-accepted principle of law. Nothing because the third party.
No, you said you issue the rule of evidence that you should be permitted to cross-examine
Yes. Then
in an assessment procedure.
yes, no. He says in the before, my lords, I have to satisfy that this is not a case of 148. This is a
True.
change of opinion.
True.
So my lords, lordship may be pleased to see the last paragraph that is in page 110. It is further requested if any adverse view is contemplated, an opportunity of being heard physically may be provided to the assessee to present the merits of the case with proper explanation and evidences, and for such act of kindness, the assessee shall be ever obliged. Now, the department has issued a circular also in 2022, my lords, that where the assessee requests for personal hearing, that should be allowed. I am reading that. And there are decisions of the Calcutta High Court, Kerala High Court, Allahabad High Court, that if the request is being made, even otherwise also, some high courts have held that as a matter of principle, natural justice should hear him. I am pressing my lords, para
Roman 8.
Roman 8. If an assessee requests
Yes.
for a personal hearing,
Then
this
maybe
may be dealt with following principles of natural justice by giving a reasonable period of compliance of notice, specifying the date of hearing. Now, my lords, without hearing, what the assessing officer did, my lords, that's the order on section 148 that your lordship may be pleased to see, and it's a 10 at page 111. And the relevant portion is 6.4, 115. He comes over. He makes a his own inference and rejects my rejects my request for personal hearing. That is the para 6.4. We will consider at the time of assessment. During the time of assessment. Why? Then
no, that was a case where they wanted that was in case of 148A.
Yes. That gives us. I am now going to a lawsuit. This is
The Calcutta
Calcutta decision is there. Then my lords,
this is very good.
first of all, just a minute, please have patience.
No, I asked him.
Sorry.
I asked.
Yes.
What about this?
First of all, this writ is not maintainable, your lords.
Why?
Because the PAN base is still now in Calcutta. The latest, I have the PAN, I have downloaded, that it is been in Calcutta. And the assessment should be, appeal it, and it should file an appeal in Calcutta.
I have also got the PAN card.
Yeah, PAN card.
Yes,
This is the latest.
I have got latest means at that time I have the
downloaded
card
also.
One day you might have downloaded, but my PAN card at the time when the search assessment was there, and after that was also when the 147 proceeding was there, was and the cause of action wholly arises here because it is a pursuant to the search operation. Then second thing, I'll bring to a lawsuit's kind this citation of the regarding the cause of action. The name, decision here. A decision of the Supreme Court, where my lord the assessor was carrying huge cash from Hyderabad to Madras. And in the Madras airport, he was caught by the income tax authorities and other police personnel. Then he was detained for 2 to 3 days, madam. Then he approached the Madras High Court. Madras High Court said, no, we will not entertain. You go to Hyderabad High Court. So he went to Hyderabad High Court. Hyderabad High Court did not entertain the petition, and he was asked to move to Madras High Court. Against that order, he went to the Supreme Court. I press nine and 10, 2 paragraphs. The first question that arises for confusion is whether the Andhra Pradesh High Court was justified in holding that as the seizure took place at Chennai, Tamil Nadu, the appellant could not maintain the petition before it. The High Court did not examine whether any part of cause of action arises before it. Action arose in Andhra Pradesh. Clause 2 of Article 226 makes it clear that the High Court exercising the jurisdiction in relation to the territories within which the cause of action arises, whether wholly or in part.
Sir, there is no quarrel to the proposition.
Yes.
After clause
Oh,
2
like,
of Article 226 is introduced
after
by way
the
of
second amendment,
constitutional amendment
Yes.
that has come.
Yes.
Now,
Now,
jurisdiction can be exercised during the territorial limits of the High Court.
correct, madam.
There is no difficulty,
Okay.
provided a cause of action arose within this.
Yes.
There are catina of judgment that a minuscule part of the cause of action,
Yes,
if a reason
much of
within
that.
that,
Yes.
there is no difficulty
Yes, no
in entertaining that.
Now, my lords, coming to the part which we are the reassessment proceeding should have
So
been-
your bone of contention, as it appears, is that this circular provides that
Yes.
in a proceeding under section 148A, when a request is made for a personal hearing, then
Yes.
the authorities must adhere
Yes.
and give a personal hearing.
Yes.
Here you have shown that I have requested for a personal hearing
Balance.
and want to rely upon several documents to
Yes.
remove the doubts,
Yes.
if it is there and in the
Yes.
mind.
Yes.
Then in that event, without
Another-
affording that opportunity and proceeding to
Yes.
culminate into a 148 proceeding or a issuance,
Yes.
this is bad.
Yes. Then second thing is that matter. May I bring to a lordship's kind notice to section 151 capital A. Every assessment, reassessment, escaping income has to be done in a faceless manner. That also is there. Section 151 capital A. Whereas when 143(3)(a) was inserted with effect from 1/4/2018, the main object of the parliament was that it should be done in a transparent manner. This is why the civility.
No, that is apparent,
Yes.
but what was latent is something different.
I don't know.
You know better.
Whereas 153 capital A said 151.
Have you
A.
provided?
Your Lordship, I'll be explaining.
Have
Your
you,
Lordship.
no.
Have you provided the personal hearing?
Lordship, Anna.
148A states,
I'll
have you provided personal hearing as he prayed for in his reply?
Yeah, that we have to verify, Lordship.
I think a circular goes in that way, then
But-
it'll have to.
But Lordship,
But once you take up this is the judgment of Justice Ravindra, but kindly also consider the judgment of Justice S.B. Sinha in Kusumingarh.
Kusumingarh, I have got
When
that.
you also, the alchemist is the subsequent
Yes.
decision, you consider it if there is a
Yes,
minute
Yes.
portion of the cause of action arose,
Yes.
then in that event, there is no fetter on the part of the High Court to entertain it. And this clause 2 is really borrowed from section 20 of the Code of Civil Procedure.
Section 20, subsection C of the CPC.
So this was incorporated. So
Yes.
no difficult,
Lordship,
same principles.
what is 148A was introduced to give an extra
Oh, there are two issues. When you just heard one downloaded information regarding PAN, then in that event, you are raising a jurisdiction point. First is the point of demo. When you raise this point of demo, then one has to understand that merely an PAN card is subsequently changed to some when a portion of the cause of action has arisen within the jurisdiction of this court.
Right.
Whether the writ petition can be maintained or cannot be maintained. You can't say solely on the PAN card being there, the entire jurisdiction vested, even if it arose anywhere in any part of the country.
That he has taken the contention that the PAN card is of
Can
Odisha.
you decide the jurisdiction on his contention? You derive the jurisdiction on the basis of a statutory provision, not on the consent of the parties or by a submission of the parties. The jurisdiction must arise from statute. Here, this is what there. Now we want that he says that in a 148A, obviously it requires a notice. It requires also an opportunity to give a reply.
Right.
Now he is relying on this circular and saying that the authority have decided that in the event in 148A, if he asks for a personal hearing, then you must provide a personal hearing. He showed us a reply where he says that I wanted a personal hearing. Denial.
I'll verify whether it has been given or not.
Is what you understand. You are taking the point here and there as if I have to argue for him.
No.
Tell us, that's the only point clinches an issue. Violation of this circular means natural justice is one of the important facets, where alternative remedy will not stand in the way. He can, no difficulty under Article 226. What?
I'll take instruction, my lordship, and verify
What we
whether
are doing?
these have been given or not.
The senior counsel have taken so much of pain at this age to argue. That's a small point.
Oh, he has not crossed the age. He is still young.
No, age is only a number. There is no difficulty.
I am 63.
He is Siddharth.
I,
He is Siddharth Ray. Against the notice under section 148 capital A of the Income Tax Act, the petitioner has given a which is placed at Annexure 9, wherein the petitioner has specifically claimed for affording an opportunity of personal hearing before taking a decision on the said notice. It is submitted by Sri Siddharth Ray Leonard, Senior Advocate, that no personal hearing was afforded, but an order has been passed under section small d, bracket small d. And challenging this same, he has come up before this court in this writ petition. Mr. Avinash Kiria, Leonard, Junior Standing Counsel for the Junior Standing Counsel, no? Income Tax Department. As appears for the opposite party, number so and so. And 6. Then got a week new. A week sir. Chutti asi hochi sir.
Calcutta no.
Calcutta se kali to sati kahiba.
Lordship, he has challenged the assessment order, not 148 AD. He has challenged the assessment order. Annexure 1. That he's taken the contention of 148 days. After that, 148 notice has been issued and ample opportunities has been given. 142, 323, 143, 2 notice and 142, 1
those
notice
are only consequences
to 148.
when finally you trigger the point. 148 notice you have issued, then those proceedings will come because it has to be.
No, sir, I didn't. I was really swayed by the mannerism in which the entire facts were presented so beautifully. But the real
balance,
real thing was not really placed. If 148 notice was thereafter issued,
yes.
opportunity to give reply was
That's
given,
the
you
balance.
gave a reply, you participated in the said proceeding,
In the proceeding,
culminated
balance.
into an order
Correct.
of the
There
assessment,
is no dispute.
then in
about
that event, that order is susceptible to be challenged before the appellate authority. Let
Balance.
him go and challenge that appellate authority. We are
So
not.
far as now,
If
now,
you say I can dictate the order.
balance, I'll submit.
No, sir. I dictate the order and saying that no, it is not permissible at
Balance,
this stage to go in.
may I bring to your, I may submit a few submissions I'll make now. My lords, first of all, your lordship have agreed that it's maintainable.
No, this is what there is no.
Now the
difficulty.
thing is that
No.
now the thing is that, my lords, whether
Yes, continue. Yes, continue, please.
no, my lords, I think
I'm trying to take out my weapons from my armory. So that is what you continue.
no, my lords, see, my lords may kindly see the so far as the mechanism provided under the Act to go into the to initiate the reassessment proceeding, that is 148. Now 148 notice is issued by the authority on 12/5/2023. Lordship, see, that is the final point where thereafter you will go into the reassessment proceeding, that is under section 143(3).
Correct, sir.
I think
No, correct.
I am not.
No, you are. I'm listening to it.
Man,
But what troubles
now-
me is very simple.
yes.
Troubles me that yes, there was a kind of an infraction.
Yes.
At the stage of 140, no doubt.
Yes.
Now 148A, ultimately, the
Yes.
authorities decided that they should initiate a proceeding under section 148.
Yes.
148A, now they decided to initiate 148.
148A, my lords.
Correct. There was infraction.
Yes.
Then they decided to issue a notice under section 148.
148.
They issued notice.
And the
And then you give a reply.
I gave
on merit.
no. Prior to that, my lords.
That is under 148A.
No, that was under section 148AB.
148 contains B. So it is a broader one, 148A.
148.
Where you say that there has been a violation. I asked him for a personal hearing. He did not provide me a personal
And
hearing.
before personal hearing, my lords, without opportunity for personal hearing, he directly issued the notice under section 148.
No.
Yes.
No.
That is your lordship, please to see. I'll just be, lordship will not see.
So it was gave you a show cause notice. You gave a reply, and then he proceeded and decided the matter. Then I will issue a notice under section 148.
Why you are so much? Well, please, maybe please to say, I don't.
When a bench has already taken up on your behalf, then why you are?
I'm adding one thing, your lordship.
Let's see.
148 notice, he filed the return.
I know, that is what I was coming. He is at the pre-148 stage. He has not really reached into 148.
Well,
he is pre-148. Means at 148A stage. He is really arguing on that.
148. Well, 148 notice, which was issued after consideration of my reply. Now, while rejecting my reply, he said, well, the question arises. And there are decisions, my lords, that also I didn't expect that lordship. There are decisions to the effect that by participating in the proceeding doesn't amount to any waiver or acquiescence of the proceeding. That's an officer of the that's a decision of the Supreme Court.
Only in terrorem then.
Then
Mere voluntary participation It is only in terrorem. Then it will not.
No, my lords, here the decisions which I'll cite, my lord, that even if the order of assessment has been passed, since you have not afforded an opportunity of hearing, the assessment order has been passed. I'll show that decision. Yes,
Kindly visualize the situation.
yes,
If in course of the one proceeding, if in course of a one proceeding,
yes,
there is a violation, you
Yes.
can definitely challenge the ultimate order.
yes,
But if there are two different proceedings,
my lords.
then you cannot challenge if the ultimate one
Yes,
is passed or ultimate proceeding is decided by following the full provisions or complements of law.
no, not that.
It is 148 and 140. 148A is a pre-conditions for 148.
148
A
capital
is a precondition
No, one
of 148.
correct, my lord. It postulates.
Now 148A culminated into a final order,
It
which invite the authorities to activate 148A, 148.
Yes.
He activated 148
he
on the basis of that order of 148A.
before the reassessment proceedings, he just a minute, my lord, can have we can be here. I will be much obliged if your lordship may.
No, we are hearing, but
Lordship may take a different view, but Lordship may kindly see the here, my lords. Even if, my lords, ultimate order is 148, that will give rise to the reassessment proceeding. If the when if the order is violated, my lords, in violation of the principles of natural justice, then how the proceeding will be maintainable, my lords? I'll cite some dissents, my lords. Lordship may kindly see this dissent.
this is on a different principles. Anyhow, but it will not be. How did you?
Then second thing is, my lords, suppose your lordship do not agree about the rules of violation of rules of natural justice. Now, so far as the mandatory procedure for completing the assessment in determining the escapement of income, that has to be done in the FACLESS manner. 153A, 151A says that. Now, I supposing, my lords, that is infraction and that is I have participated in all this.
This case does not really fit into the present facts. What is this case? This case was that 148A proceeding was initiated. There was a violation, and then an order was passed on the basis thereof. 148 show cause notice was issued. Now they challenge that show cause notice that it is in violation because 148A you did not follow this. Now, considering this, they say that no, that you cannot do it because you'll have to give an opportunity. Here, the fact is that after 148 notice is given, you gave a reply, submitted to the jury, participated in the proceedings, you gave all the documents, everything you gave, and thereafter the authorities passed the assessment orders. Now at this stage, can you say 148A you have not followed? Can you say? And this is a judgment I can give you one very on a different principle. But on the same analogy can be drawn.
Yes.
That once you submitted to the jurisdiction.
I'm not on.
The later on, you cannot turn around and then challenge that I have.
I am withdrawn. Now, my lords will kindly see.
That's a principle of acquisition.
I have principles of acquisition. But, my lords, kindly see. 151 capital A. Can that central officer of Kolkata division pass an order in violation to the language of 151 capital A? Lordship may kindly see. 151 capital A. And there are judgments of various high courts that income escaping assessment has to be determined in the manner.
I am conscious that is mere change of opinion does not come under the purview of escapement from the notice of.
Yes.
That is, I am conscious.
Yes, you're conscious. Very good. Then your lordship may kindly see. Faceless assessment of income escaping assessment. Any of the notification officer that direct that any of the provisions of this act so, my lords, for conducting inquiry, issuance of notice or passing of order under section 148A, sanction for issue so as to import greater efficiency, transparency, accounted by eliminating interference, optimizing utilization through economies of scale and introducing a term team-based assessment, reassessment, recompetition, or issuance of sanction of notice with dynamic jurisdiction. Now, my lords, after this, I'll cite several judgments of different high courts that he has. Now, your lordship may kindly see the order of assessment. Of the Bombay High Court, there are several high courts which have held that in the case of reassessment, you have to faceless manner has to be approved. Lordship may be pleased to see.
Yes.
Yes, my lords may be pleased to see the High Court of Bombay. Then I'll bring to the kind notice of the judgment of the Punjab Haryana High Court, Telangana High Court, and including this honorable court. Where their lordships have held that it has to be done in a faceless manner. I am not on natural justice. I am on the question of mandate of section 151A, and we saw, and you have to do it under section 144, capital B, subsection 2, in the manner prescribed by the CBDT, and those notifications I have also enclosed. Para 36.1, then para 5 of the judgment, where this Honorable High Court of Bombay has followed its own decision in Hexaware Technologies versus Ashton Commission versus Ashton CIT.
Just a minute.
Last time.
Yes. And 128. Annexure 13/A, page 1 to 8 of my writ petition.
Yes.
Lordship may kindly see, the central government has given the notification.
That portion which was dictated, let that be there. There are between parts. Page 147.
The scope of scheme. For the purpose of the scheme, assessment, reassessment, under section 147 of the Act, issuance of notice under section 148 shall be through. It says shall be through automated allocation in accordance with risk management strategy formulated by the board as in relation to section 148 for the issuance of notice and in a faceless manner to the extent provided under section 144B. 144B subsection 2 says the faceless manner as is provided under that.
Yes.
So another decision matter we have yes, several high courts matters have held that then Lordship may kindly see Punjab Haryana bill. The High Court of Punjab and Haryana matters, para 36, 35, sorry. The para 11 after para 11 they have referred to the Bombay High Court judgment, example. Then my lords. They cannot resolve the jurisdiction of the faceless authorities, that is CBDQ matters which has been conferred. They have formulated a scheme, who will be there, who will be not there. The jurisdiction licensing officer has no business. He cannot impinge upon the jurisdiction of the faceless. Now, matters I will cite your lordship. Another decision of the another High Court matters, with great respect matters. Lordship may kindly see the judgment of the Punjab Haryana High Court. Page para 14 and 15. May be pleased. And then I'll come to our High Court where coordinate bench had decided the matter. It has to be done in a faceless manner. And did not give any material that the jurisdiction of the AO is concurrent faceless. That was not the case. It is not the case matter. That is not concurrent. Lordship may kindly see. The respondent during the Telangana High Court. Perusal of section 151A, it is quite evident that scheme of faceless assessment is applicable
From all the judgments have really relied upon a Bombay's judgment, that is a foundational judgment.
Yes.
In Hexaware.
Yes.
And this is also followed the
Right.
Hexaware.
Exactly.
No need to cite the further
Yes,
judgment.
it's not just for my. So that
No need to cite. Your junior may prompt you to cite, but don't cite.
That's right. So, madam, I'll just cite
Let
one.
them be reminded of a Rashmi Matalik judgment of the Supreme Court delivered by Justice Vikram Gisel.
And
Paragraph 6 or 7 of that judgment. For juniors, not for you.
well, so, my lords, if Lordship knows this proposition of law that mandates a thing to be done in a particular
Nazir
manner.
Ahmad is known to me in
Yes.
1936 previous.
Yes, Privy Council followed in that is Manohar Lal Sharma and so many judgments versus Union of India, that PIL coal block matter also. Justice Lodha has also repeated the same thing, madam. So here the notice, starting from notice to the assessment order, has been done manually. That is my and
Let us hear him.
yes.
Now.
First of all, one if search is being conducted, this faceless assessment is not applicable to them. Second, what the decision he has cited, after that, Delhi High Court has also given in our favor. 5 court has given in our favor. Calcutta High Court has given 2 decisions in our favor. Madras High Court and
You bring those judgments.
TKS Builder with Delhi High Court has
Give
given
me
in our
those
favor.
judgments. I'll see.
Decision. And Lordship. And this is his SSC has been searched. Once a search has been done,
Let me
all the
clarify here,
assessment-
madam. Please,
all the assessment will be done manually.
Just with your lordship's kind permission, I'll just take 1 minute. The search, I am not on the search assessment. Search assessment, my return has been accepted, which my lords have said. Now, after the search, recourse was made
Now
manually.
the question is, if
Yes.
anything originates on the basis of a search,
Yes.
then in that event, so which would assume jurisdiction?
Yes.
It's a faceless or it is a jurisdictional commissioner or jurisdictional assessing officer who will.
Yes.
So this is
Correct,
this is the basic fundamental question.
Yes.
Has been answered by many courts,
Yes.
which has not been taken into consideration in Bombay, Hexaware,
Yes.
and I think
Right.
the Calcutta view of Justice Sivagnanam was very clear on this.
Then, well, let's here, Lordship will kindly appreciate one. After the search assessment was completed, it was over there. Records were transferred.
It's a judgment of Justice T.S. Sivagnanam.
And with Hiran Bhattacharya, madam.
He is Hiranmay Bhattacharya.
Hiran Bhattacharya, I think I have. That was not with regard to faceless. Not with regard to
It is in relation to a search and seizure. It was search and seizure. Anyhow, we are not entering into all these aspects. Let them vindicate the grievance in another forum. There is a very good forum for him. So let him.
And let's, so far as the appeal is concerned, madam, where I will file the appeal? That is the question, madam.
We just wanted to avoid, if you want us to decide, then we will decide those points and that will, I do not know, will affect something else.
That is.
we are not really expressing a final opinion, because if we express the final opinion on an accused, then that will create a lot of problems into the SSC. We do not express this. The instant writ petition is filed, assailing the order of assessment passed under section 1 of the
No, it is passed under section 147, read with 143.3.
No, only 147, your lordship, page number 21.
143.3, unless 143.3.
In relation to a proceeding under section 148 of the code. In context.
147. Yeah, that's super.
So we can see once order under 47
Correct.
pursuant to notice under 140.
This is what, in relation to a proceeding under section 148. Just said in relation to a proceeding under section 148 of the Context Act. So, it is a specific stand taken by the petitioner that the precondition of the show cause to be issued under section 148 of the said Act was an outcome of the violation of not only the statutory provisions contained under section 148 capital A of the said Act, but also the circulars / notification issued subsequently. First off, in other words, it is sought to be contended that a principle, contended that the authorities must afford opportunity of personal hearing in relation to proceeding under section 148 capital A of the Act in the event the SSC conveys such intention, and therefore denial of such opportunity would entail the entire course of actions adopted by the authorities liable to be struck down. It is further submitted that the steps under section 148, which culminated into an order of assessment passed by the assessing officer, is consequential to the adherence of the provisions under section 148A, and in the event the steps or the course of action adopted under section 148A is found to be illegal, all consequential steps shall fall automatically. So, it is further submitted that the authorities have not taken into consideration the nuances of section 151A of the said Act, and cannot assume the jurisdiction in violation thereof. The reliance appears to have been made upon the judgments where the authorities did not adhere the mandates of section 148A, which were found to be illegal and contrary to the settled proposition of law. And the interference was also made to consequential steps / orders passed by the authorities. There appears to be a debatable issue in this regard. Stop. Whether the assessing, whether the jurisdictional authority in view of section 151 capital A of the Act, 151 capital A
Yes, ma'am.
of the Act.
And also the instruction letter.
Yes, on the Act.
Annex A 30,
Can
ma'am.
assume jurisdiction,
Annex A 30, ma'am.
can assume jurisdiction and proceed to decide the
Page
same,
125.
despite the fact that such a jurisdiction was usurped after the search and seizure.
After the search assessment was
Search
passed.
assessment, after the search assessment.
Yes.
I have a different expressions which I use there, so I am adopting here search assessment after the search assessment. Correct. Stop. The point which is urged the point which is urged in the instant petition is at the stage of an assessment order after exhausting the provisions contained under section 148 of the said Act. There is no fetter in maintaining the writ petition before the High Court. Despite an alternative remedy by way of an appeal having provided in the statute, but the High Court may, at times, refuse to exercise the discretion if the point so agitated is amenable to be agitated before the statutory appellate authority, who is also competent to decide the same. There is no fetter on the part of the statutory appellate authority to decide the jurisdictional issue, nor such power is fettered in the sense that it cannot enter into the decision of the appellate authority if it is demonstrated before it that the same is passed not only in violation of the principle of natural justice, but also in flagrant violation of the statutory mandates. Though initially the point raised on the course of action under section 148A of the Act looks attractive, but our attention was subsequently drawn to the fact that immediately upon a decision having taken under the said provision, the notice under section 148 was issued, and the petitioner participated in the said proceeding on the basis of the said notice, and which resulted into a culmination of a final order of assessment. since there is a express provision, section 250.
A.
250.
For appeal, 246A.
Yes. Yes. What I said is provision. Of an appeal against the order passed under section 147 of the said act. Is said that by virtue of section there is an express provision of an appeal under section 246.
A. Capital A.
1B.
Yes, it's just 246 capital A of the said act. No, I'm saying. Yes. That is there. You have seen 46 of the said act. It would not be desirable to interfere, as we find that such comprehensive remedy is already provided in the statute. Stop. We thus do not intend to exercise our discretion so vested under Article 226 in this regard and relegate the petitioner to explore the remedy as provided in the statute. The writ petition is thus disposed of. We have consciously avoided, but there was a problem.
It's all right, my thoughts.
We consciously avoided because any observation will really sway or curtail your right. We do not really. I was very cautious about it that no observations would come like this.
Very good.
Item 24.
Lordship said GST problematic. In absence of GST,
10%. We have kept the matter when.
Ajikar, I would case also. Episode below, I would put case 10% filter bill. 21.
Item 21. Yes, sir.
21.
Yes, sir.
Yes, on the next.
Item 25.
Yes, sir. 21. 10% 23rd set up. Tag कर देता है.
The proportion of fact involved in the present case, your lordship, is that an assessment order, your lordship, had been passed by the FACLESS assessment unit. Your lordship, in pursuant to a show cause notice, your lordship, which is the invalid one, in contrary to the standard operating procedure issued by the National FACLESS Assessment Center, in terms of provision of section 144 capital P of the Act. That's SOP, your lordship states, at 7 days must have to be give in order to respond to show cause notice. But here is a case, your lordship, only 1 day he has been giving prior to passing.
Why you are not giving it 7 days?
Lordship, show cause notice, your lordship, is at case 72 minutes. This is issued on 7th March 2025. My lord's date of hearing 9th March 2025. Respond only 1 day prior. Various honorable high courts, lordship,
Yes, yes, I'm asking him.
Your lordship,
Is it 7 days is the mandate, then why 1 day?
some
Is a
time
short of.
given, your lordship, that is there.
That is there, then it has to go. And now
We
the question
remanded-
is, how many days you have already availed? Let us see that it was short. Then what the authorities did you give you an opportunity after 7 days also?
No, Lordship, he issued notice on 7th March 2025, passed the order, final order, Your Lordship, on 11th March 2025. Just
When he issued 2 dates, yes.
7th March 2025, so cause notice issued, my lord.
Good, and
Final order, Your Lordship, has passed on 11th March 2025.
oh, then within 7 days,
That
then
is
it
also
cannot.
within 7.
Then it cannot.
Adequate option.
Your lordship.
Where is the mandate of 7 days?
Yes, my lord. Well, sir, I have
Where is the SOP?
SOP, Your Lordship, kindly have glanced to page number 38, my lord. They give page 38. 38, my lord. Mals N13.
Yes.
But to ensure adherence to the principles of natural justice and reasonable opportunity to the assessee, timelines to be given for obtaining response to the so-called notice shall be, Lordship, 1, response of time of 7 days from the issuance of so-called notice.
Yes.
Response time of 7 days may be curtailed, keeping in view the limitation of completing the assessment.
So it can be curtailed, keeping in view
Yes,
of the.
Milords, the due date of passing the final assessment, Your Lordship, on 31st March 2025. Your Lordship, assessment of 2021, Your Lordship, barred by limits on 31st March 2021. Still time is there with the.
Yes.
Your lordship, here, this so-called notice was given at last, earlier 148 notice, 142, and all this notice was given.
Whatever.
Then this was
But
a
if
variation
it
notice,
says that this so-called
then
7 days time, and within 7 days you have decided and passed an order.
and let me remind back to the assessing officer to give an opportunity, and he'll take the conclusion. Your lordship.
The difficulties have you seen? Some big thing has already intervened. So you realize. Is the completion of an assessment. It is not mere.
Let me take instruction, Your lordship.
How much money?
Lordship's amount involved in presentation of page 20. Lordship's amount demand 4,94,614. Lordship, matter may be restored. We can Lordship.
The assessment order, it is written that dates of issue of notices under 142.
My lords,
18/7, 18/7/24 and 7/10/24.
yes, my lord.
Already you had availed.
Yes, my lord. Prior to this impugned so-called notice, Your Lordship, entire statutory notices I have duly complied, my lord. Even if Your Lordship,
This is in continuation of that.
Yes, my lord. And Your Lordship will appreciate, my lords, this is the addition on what basis Your Lordship, it is a totally new one. My lord has not given a single time to respond this week.
Yes, what do you say?
Let me take instruction.
Come take an instruction. When?
2 weeks, Your lordship.
Take instruction 2 weeks. Come.
15. Orders item 26.
No corrective action, Your Lordship.
They will not.
Item 26.
There's a delay of 59 days.
Notice?
Yes, ma'am.
Have you given?
My here no state is not a party, madam.
Or then the notice is to be given requisite within 2 weeks.
Well,
Matter to appear after.
We normally say 3 days. 3 working days.
Yes, I'll find.
Requisites within 3 working days.
yes.
Do it.
Same. Registered post or split post, emergency.
Yes, call.
Item 27.
Continuation, how many days?
State.
Not clear. How many days?
2.5 years, ma'am. More than 2.5 years.
875 days.
Have you filed your counter?
No, I have not filed counter, copy has not been served. I have my not,
No, to IA, IA you have received.
no copy.
You have not.
My name is not there in the public. And though I have appeared on 9/15/25.
You have already appeared.
Give him a copy and give a counter because it's a
What
long
is your name, sir?
Ramadan Shah.
Ramadan Sahu. Advocate appeared for opposite respondent.
Respondent.
Right.
On which date you have filed wakalatnama?
9/April/25.
9th April 25.
Yes.
Yes. And reflect his name in the cause list. Copy of IA. Copy of IA limitation is served in court today.
And
This is
my
matter.
objection. I find my objection.
Yes.
A similar letter has been filed on 12th May. 12th May.
Let us see. Let us see. You.
Both IA and
No.
both
No. Only IA.
IA only, I was referred to.
I copy of IA. अपन कॉन्डन होगा ऐसा कितने डिले है
Common.
Yes.
Item 28.
By which date you will file
By 12th May.
objection?
12th.
By 12.
12th May. 12th.
Yeah.
12.
12.
Item 28.
May I please your lordship? I am on VC my lord. Pardon my lord because I have fractured my leg. That is why I am on VC my lord. I have filed my vakalatnama on behalf of opposite party number 1, that is Cholamandalam General Insurance Company, on 21/4/2025. I will be permitted to file counter. The matter may be taken up after vacation because I am not in position now to draft my counter, my lord, because of my leg fracture.
Yes. This is the application for condonation or what?
Delay.
How much days?
My lord, 17 days.
17 days. What counter you will file, madam?
No, my lord. As far as condonation of delay is concerned, your lordship may condone the delay.
Yes. So let that be done.
You are appearing for
OP1.
OP1. Respondent 1.
Cholamandalam General Insurance Company.
2 and 3.
Two is already appearing. Who is not appearing today?
No, the office note shows.
My lord, he has not been assessed.
No. Respondent number 1, it came back. Now respondent number 1.
Mr. Mihir.
What about 3? Are you appearing for 3 as well?
No, my lord. Only 1.
Flag X car, flag Y car.
What about the Odisha diesel service? Respondent number 3 opposite. What has happened?
My lord, despite service of notice, respondent number 3 has not.
What is the office note, sir?
What it says?
Sir, office note says 1, 2, 3. AD has not come back, but
1 has now appeared.
now
2 is already
that is
there.
sufficient. No, X and Y. Sure.
I can deliver.
Respondent of 3 is the office flagged or tracking the code is in transit. Okay. It is in transit.
In transit. So respondent number 3, not first. Respondent number 2.
Sir, respondent number 2 last time appeared. This is already happened. 1 is now appeared.
So 1 appears. 2, 1 appeared. The Rimjam Bala Pati. 2 has already appeared on earlier date. 3 has not yet been served. Awaiting service return. list this matter. And tracking report, further tracking report we placed on record on the next date.
Item 15th.
With regard to respondent number 3.
Yes.
Huh?
Item 29.
Right.
For the respondent,
Who is for the, how much days delay?
Delay, my lord, around
185.
What do you say?
my lord, may some of the delay may be controlled, my lord. Delay and matter will be hard, my lord. Yes. Person.
Come on. For the reason stated, Mr. Durkesh has no serious appeared for the respondent. Only
Sole response.
sole response.
Yes.
Mr. Das. Have you got the
I have a copy.
memo?
I have a copy.
Memo copy?
Read up, I have a copy, read up.
You have already, sir. List this matter.
Say submission.
Say submission next week, madam, because since 2018, I am not in service. I have been disengaged.
There is already an order of reinstatement, no
My lord,
problem.
they have not yet complied. When I filed a contempt, my lord, they said writ appeal is pending. Accordingly, contempt was dropped, my lord, because on the basis of pendency of writ appeal. Thereafter, we take initiative for mentioning.
Where is the bar? Where is the bar of?
Contempt has been dropped, my lord, since writ appeal is pending.
Dropped or disposed?
Dropped, my lord. Giving liberty after disposal, you do an application for restoration.
Yes.
13th.
Next week, my lord. Yes.
Item 30.
13.
My lord.
Item number 30.
How much days delay?
1 month and 26 days. 1 month, 26 days.
1 month, 26 days. So 56 or 57?
In between.
In between 56 and 57, what comes? I do not know any numerical number in between 56. Complete number.
In 2 months.
You say 1 month, 26 days. If we calculate 1 month with 30 days, so it is a 56 days. If it is 31 days, then it is a 57. You say in between 56 and 57. Where is the complete number between 56 and 57?
60 days. 60 days minus 4.
25 days.
25 days. Yes, what do you say?
No.
What do you say?
Central government, I am appearing for the opposite party number 1 and 2.
That 25 days delay.
We get it. Condemnation delay.
Delay.
Yes, delay control.
Yes, sir.
Saraj company.
Senior panel comes.
CGC.
Senior panel
panel
comes. Appearing for opposite party 1 and 2.
1 and 2. Any other party?
Other party.
3, 4, 5. Who is appearing? Service sufficient. Other respondents?
No, the union of
respondents.
Single.
No. 3, 4,
5
5.
respondents appearing on behalf of the
Mr. Mandal. Service is complete against respondent number 3, 4, 5.
3, 4, 5.
Service is complete now. Richie.
No notice it is.
Notice issue है नहीं सर्विस के तले
Insufficient.
Mr. Mandal, you are required to serve copies on all the respondents or not?
No, that has not yet been solved. Not been solved.
Not been served. So you
Yes.
to respondent number 3, 4, 5.
Appearance is a piece.
है ना? Notice in IA. Notice in IA.
My lord.
3 working days. File requisites within 3 working days. Against 3, 4, 5 because Mr. Manaspati has already appeared for 1.
1 and 2.
No need to issue notice. है ना? You have served copy. Copy of IA has already been served on Mr. Manaspati. है ना? To other respondents 3, 4, 5 issue notice in IA.
Next.
19th June. Item 31.
How much days delay?
Subsequent development in laws of the manufacture.
It has become contentious.
Because there is an amendment to the Realization Reassessment scheme. Now the date of
What to do?
that is the direction which is given by the learned single judge that the applications have to be considered as per 1990 rule. And the present amendment also states the same thing.
Rehabilitation assistance.
Yes, my lord. If I may hand over my lord. Please.
Yesterday we have not finalized yet. We will see in terms of that order paper. Yesterday.
Yesterday we could not.
No. No, I have dictated already. I'm just. And answer Santosh and Malayan on the city. Open dictation. So
Disposed of.
Undisposed.
Item 32.
How much days
My
delay?
lord, my lord, 19. I mean, BC, my lord. I beg an apology for appearing to this BC.
How much
19
days
days.
delay, sir?
19 days delay.
Yes. Have you served upon the other?
My lord, the other side is the Punjab National Bank. Notice to.
So you'll have to give a notice, sir.
Yes.
So you issue notice. We are issuing notice, sir. Requisites within 3 days.
Okay. My lord, since the delay is meager, my lord, lordship can.
No difficulty, but a right is accrued because of the delay, so they must be notified. No difficulty. Come back after this.
Ajay lordship register.
Item 33.
Yes. How much days delay?
51 days.
Condoned?
My lord, in this case, the content petition has been dropped after filing the personal appearance was ordered by this honorable court. After personal appearance, they filed writ appeal, and on the basis of writ appeal, contempt dropped. Contempt delay will be hard this matter because otherwise the petitioner is not getting the regular salary in spite of the next week, man.
Well, I am appearing for the response number 11 and 10 and 11.
151 days.
As the instruction. I have not filed to I created the copy of the something.
Sir.
You are appearing for?
Next. Respondent
Respondent
number?
number?
10 and 11. Paichantu and
Barampur University.
Barampur.
Mr. Dr. Purushottam Chulli has instructions to appear on the respondent numbers 10 and 11.
Sir.
Copy of IA is served on him.
I said survey. I don't know.
Then others, you are
Who is appearing?
nine you can appear. Nine you can appear. 9 there is no necessity. Finance department. Pro forma. Then 1 to 8. You are appearing for 1 to 8.
Sir.
Mr. Manaspati. Copy देइछन.
नहीं.
आइए copy देइछन.
अच्छी copy.
I'll serve it by tomorrow.
Should have made ready. 251 days delay. Sir, copy.
I'll serve it tomorrow.
This Aishwarya Das, an additional standing person, undertakes to serve copy of IA within 3 working days on Mr. Manaspati and Dr. Purushottam Chulli. Hello? Sir. Okay, but next week. Next week, sir.
On 8th.
He is not getting served.
Item 34.
In
34.
134 days.
Other side. Notice has been issued? No. Serious notice.
Item number 35.
35 not 7 days.
Notice. Other side.
My friend is not delays that we have filed the OTP.
Easy. Is the respondents appearing?
It's not
Lots of.
Have you got a copy of the condonation application?
No law.
You will appear for other side, Mr. Adhiraj?
Lots of.
Then
Service. In both the matters.
for the matter.
you have instructions to appear or filing wakalatam?
Filing Wakalatam. And just a certificate.
Adhiraj Mahan.
How much days delay?
7 days later, delay is not there just week. But I have filed the OTP. But the OTP they are not rejected due of non-compliance of the defect. Thereafter, I filed a further appeal. And fast appeal is within time.
Fresh you have filed.
Yes, therefore delay not. Fast OTP is filed. If we agree not, then delay upon nursing may put for further I guess. File objection.
57 days, what objection?
Senior counsel to appear. So we will have.
And we have time.
Or,
Yes.
no, if you want time to peruse, there's no difficulty. We can give them a time. If you want time.
No. One of the delay, I disposed of. Okay, appeal to list this matter on.
14th May.
Okay,
14th May. 14th May.
Copy of OT appeal you have received.
Alright, sir.
OTPL under the copy of OTPL has been solved on Mr. Adhiraj Mahan. Please this matter on so.
Our name may be reflected.
वकालत दिले पर
Item 36.
May I agree? Lordship, in this case,
both the matters.
Yes.
Both the
seven, 6 days delay. I have explained in my IA, your Lordship's time I glance to my IA para 1.
I'm more concerned actually.
Lordship,
In this I am concerned.
your Lordship.
In division bench. Is it not that matter? Single bench. Single bench.
Honorable Supreme Court directed to file review, given a liberty to file a review petition. They filed that review petition in the dispose of read petition instead of read appeal.
Right, in single bench also.
Yes, yes, sir. That is matter. Their minors are not expressing opinion, accepting a discussion that yes, this can be because the petition can be merged with appeal order. So you could have filed a review in appeal. Still, why you are filing it up before the single bench? That was the thing.
Yes.
Your Lordship are not confident. My Lord, I have explained in my IA para 1, my Lord, I will have a glance.
No, what is this review? Is it delayed or is not delayed? It's delayed by many days.
776 days.
What is this IA?
IA for condemnation of
23.
Yes, my Lord.
Yes. Yes.
My Lord, petition was filed the aforesaid writ of appeal challenging the order dated 15/1/2018 passed by the Honorable Single Judge in WPC number so and so, wherein direction to the petitioners to pay the arrears party number 1 and 2, that is the petitioners from
No, we have already read. What is your submission?
only my submission after liberty granted by the Honorable Supreme Court. Inadvertently, I have filed a review against the order of the Honorable Single Bench instead of writ of appeal. That is my mistake.
No. This is a review of the division bench order.
Yes, my lord. Yes, my lord.
So when the division bench passed the order on merit,
My lord.
26/10/2022.
Yes, my lord.
26/10/2022.
15. Yes, my lord. Yes.
26/10.
Then you challenged the order.
Before
You withdrew it on 20th or 29th March 2023. Which one is correct?
29th March.
29th.
29th March.
Yes. Then you filed a review.
Yes, my lord.
Number 267.
267.
When
Review before the single bench.
Before the single.
I was there.
how can you review the you withdrew it?
Yes, my lord.
Then you filed this review against the
Division bench.
Incidentally, it came to this.
My lord, not to withdraw. The review court has granted a to file a review.
Single bench.
Honorable single bench.
under what circumstances
Lordship kindly.
this liberty is granted, sir?
Petition order.
Sir, I am aware. Under what circumstances this liberty is granted?
As liberty granted by the Honorable Supreme Court.
Under what circumstances?
As has been granted by the Honorable Supreme Court. That's it.
Paragraph 4, madam.
When this review is filed,
So year 2023, my lord.
This review, my lord, this review is filed on, my lord, 23rd December 2024.
December.
December.
And when he withdrew the single bench, that was November.
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 So what is there? He has been pursuing diligently. It's not that there was a negligence on his part, but before the wrong forum.
May I submit, my lord, there also, my lord, knows about the consultation petition under section 5 of the Limitation Act. My humble contention, suppose, my lord, so that it will be treated as a section 14 petition. Then also bona fide. I filed objection.
No, we are not treating it as a 14.
Fine.
Let us see that he has been bona fide pursuing his remedy under the whatever the advice.
Yes.
And advice appears to be wrong.
May I submit, my lord? Thinking that they have gone to Supreme Court against the division bench order. On the Supreme Court, I granted review petition before this court, my lord. Already previously marked before the division bench, my lord. Knowingly they filed a petition before the single bench. And that too during, my lords, this matter was taken a number of times. And there, my lords, my case, specific case is that is the review that amounts to it, my lords, appeal order, and review should have been filed. Instead, my lords, they pursued, my lords, and in spite of the advice also, they can withdraw, my lords. They are now pursuing.
What could be done?
Then
it is not a sufficient
they cannot plea a bona fide, my lords. They cannot plea a bona fide, my lords.
We can dismiss the review.
Sir, cause or bona fide, my lords.
Section 5.
From the date, my lord, the order part.
It appears that he preferred the special petition against the order, which is now sought to be reviewed. The order which he want a review, that order was challenged in the SLP. SLP was withdrawn. The liberty was granted to file a review. Immediately thereafter, they went to a single bench,
Then also,
filed a review application.
then also there was a delay, my lord.
How much?
300 some odd days.
Oh, they were already in default.
Yes, my lord.
Yeah.
Yes, my lord.
The delay has been condoned.
No.
In that case, single bench order.
Oh, single bench delay was condoned. So 300 days goes, then he take advantage of this.
Okay, that is there.
So
After, my lord,
thereafter he withdrew.
no, he withdrew, my lord, at a subsequent time. Before that, man, can you visualize what?
And immediately after the withdrawal order, he has filed the instant review.
That is correct, man. Before that, man, number of.
So condonation,
Yes, man. Condonation.
review may be dismissed on merit,
Man.
but condonation, and it appears sequel of events shows that he was pursuing. After 11/11/2024, when the order was passed by the single bench, I think he has filed the review on 23rd December.
That 23rd December 2024, man, they filed. There is no dispute on that, man. Man, only thing is to consider, man, whether if they are filing a petition before the honorable single bench is bona fide or not. Knowing well, man, that the corporation, man, it is a corporation, responsible officers, supported by, they have their law officers, advisors. In spite of that, man, they have done it, and we have raised that point in the man's petition also. Petition for condonation.
But somebody must have advice. They have to act on the advice. And if the advice appears to be wrong, then
That is a wrong advice. That is also not been stated in the petition itself.
it's not stated.
No, my lord.
I have stated inadvertently the petitions are filed. Review petition we are so and so against the order of the honorable single judge instead of appellate order.
My lord. That is, my lord, that is also not been taken.
Totally wrong advice, my lord. Former counsel. I am not the counsel, my lord. Earlier, I am not the counsel.
That change of counsel, my lord, doesn't substantiate the reason. That there is no particular, there is no contention about wrong advice.
That's true. EIR 1997 Supreme Court 1007.
Mr. Panigre, how can you file the review, maintain the review by change of lawyer?
EIR 1997 Supreme Court page 1007. Read that judgment
My lord,
and look at the strong observations of the Supreme Court in paragraph 2 or 3 of the judgment.
Yes.
Or paragraph 1.
Yes, yes.
First paragraph. It's a very small judgment, not big one. First paragraph. Now, cross the hurdle. Yes, you say, but cross that hurdle. 97 Supreme
97 Supreme
Court.
Court. 97 Supreme Court, page 1007. 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 97 Supreme Court, page
Yes, sir. What to do?
Okay.
You go through that judgment.
Yes, ma'am. I have
Please go through.
gone through. I will gone through.
Yes. When? Today evening? Today evening?
Yes.
So tomorrow morning fixing this matter?
No, ma'am.
Why not?
In a division bench also, in a division bench sitting along with the Honorable Chief Justice, I have passed a judgment also in the same lines, following Supreme Court.
Following 97 Supreme Court.
Sri Temple Administration. Mr. Subra Satpathy was appearing. Division bench. Just 2-3 months.
2 months before, madam. 2-3 months before, madam. I'll find out. Find out.
For following Supreme Court judgments, I was party to that, and I wrote the judgment for the bench.
Now there is a second hurdle. One hurdle I have created, now it's the second hurdle. Now you'll have to convince my brother judge that change your decision.
Original writ appeal, I was the party. I was member.
Yes, ma'am.
Twice you have to. 2 hurdles, sir.
Wait for my change.
That's the convince him to change his opinion. Yes.
It's on 8th. On 8th, next week.
When? Let him say. Do one thing. We have completed all this. Only the admission has been left.
Yes.
So tomorrow you fix those admission first.
No, he says that once it comes election. In our Orissa,
For admission.
admissions never come to the top. And sir, after sitting, we can fix, we can ask the bar members when the admission.
Admission.
I